You are on interim?
Yes, ma'am.
Yes, what is the CS number?
My lord, sheet number 6/26, dated 31/1.
Then we are going to extend your interim up to
Yes.
15 days. You will.
May I please, Your Lordship? So I beg to mention item 32, Lordship.
34.
32, 32.
Three.
Lordship, when the CD was called for, perhaps CD not reached, Lordship.
Not this.
Petitioner is not interim, Lordship. I pray for short date, Lordship.
You are not on interim.
Lord.
They did not receive. So reminder. From where it has to come?
Jorhat, Lordship.
Jorhat.
Can it be this month, Lord?
This month? My lord, 5th of March, my lord.
Short date.
It's many matters. So maybe on second then.
My lord,
Second
second.
of-
Second.
Second of
Much obliged.
May I please, Your Lordship? I beg to mention for listing one criminal revision petition, Lordship, in motion column, Lordship. Wednesday, Lordship,
five. Oh,
deeply obliged.
May I please, Your Lordship? I beg to mention for a IA in criminal petition which was last listed on 7 January, but it was not reached, Lordship. Lordship, this matter may be taken on 5th of March, Lordship.
it may not be. Second of March.
My lord, I beg to mention one bail application for motion, if possible Monday. Motion matter, POCSO matter, only notice should go. Obliged.
With pleasure, Lordship. Lordship, I beg to mention item number 35, Lordship. While hearing witness, Lordship, but I have some personal difficulties on today, Lordship.
What is the position? CD receipt. Are you on interim then?
No, Lord.
You are not on interim.
Yes. Can it be on Monday or?
The replacement by the reside. CDP retained till next date of listing. This accordingly Monday. I don't know. Monday. Oh, that is 26th at least.
Lordship. Obliged.
We are retaining your case.
Fine.
Lordship.
May it please, Your Lordship, I beg to mention for listing one of criminal revision petition, Lordship, for hearing. Lordship, matter may be listed next week any date.
26th is Thursday. 26th is a Thursday. Twelfth of March, you say. 12th of March. She's a hearing day. It's a hearing day. We are fixing it on 12th of March.
But I beg to mention item number 30, my
30.
30, my lord. CD not there, my lord. Petitioners are not interim.
She did not receive. Issue remain. Yes, when it can be.
Interim. Secondly,
13th, my lord. 13th.
1-3.
and
30th
another
of
prayer
March,
for listing of
interim be continued till next.
listing of a fresh bail application, regular bail. Ma'am. If it can be possible on Monday, my for CD only, my
Many matters have been listed.
then
Okay, we'll try.
Tuesday.
May I please, Your Lordship? Your Lordship, I beg to mention item number 14, Your Lordship. May be taken up next week, Your Lordship, on any convenient day, Your Lordship.
1-4.
14, 1-4. Motion,
It is in motion call.
motion, Your Lordship. Due to some personal difficulty of the senior counsel, Your Lordship.
The request for it. 27th of March. Oh,
But-
sorry, 27th of
Much obliged.
May I please, Your Lordship, I beg to mention item number 39. Only matter may be adjourned for the day
39th.
39. Date may be fixed, Your Lordship. 39.
It is in order column only.
Yes, Your Lordship.
The request witness.
Service please, sir. Notice already served.
2nd of March.
Obliged, Your Lordship.
May I please, Your Lordship, item number 10, kindly wait for adjournment. The engaged counsel is not well for today. Kindly give a date after a week.
It is not given. Matter is adjourned. Is to- See, 25 matters will be listing it after 2 weeks as on a date to be fixed by the registrar.
May I please, Lordship? Lordship, I beg to mention for listing of a matter for hearing, Lordship. Any date on next week, Lordship, because
Don't have any.
maintenance has been stayed since 1.5 years, Lordship.
Whether we don't have any date on next week. And based on 10th of March, it's a hearing day. It's a hearing day on 10th.
Obliged, Lordship.
May it please your lordship, I beg to mention a listing of a criminal appeal, your lordship. It's currently in the part 2 hearing list, part 2 matters. The appellant is like behind the bars for last 6 years, your lordship.
6 years.
Yes, your lordship. He was punished for 11 years total, and matter will be listed on 3rd of March, your lordship.
Third is not hearing day.
Uh,
Is it a hearing day third? Third and fourth is holiday.
okay.
And fifth, we have already fixed many matters. At best,
Any date, your lordship.
17th of March.
Obliged, your lordship.
May I please your lordship, I beg to mention for listing of a regular bail. Kindly Monday, lordship, more than 70 days behind the bar, lordship. Thank you.
25th.
May I please, Lordships, I would like to mention item 37, my lord. Also, order matter, my lord. In that case, my lord, I am for the petitioner, my lord. Already, my lord, matter has been amicably settled, my lord. They will file, my lord. Respondent number 2 will file affidavit, my lord. That's why, my lord, some already not appeared, my lord, till date. That's why I am praying, my lord, for fixing a date, my lord, on 24 or 26.
Why you're praying? You are for the petitioner only.
My lord, already not, my lord, appeared. That's why, my lord. I have some other, my lord, medical burden also, my lord.
You see,
That's why.
your reason you are praying. Why you're blaming the other person?
No, they have informed me that, just, my lord.
Ah.
They have informed me that's
What information?
my lord, respondent side, my lord.
What they have informed you?
They will file affidavit, my lord.
Oh, okay, then they will submit. It is your ground why you're taking a job.
Yes, 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 my lord.
At the request made by land cost. That will be a job.
26 or 27, my lord.
No. It will be on 6th of March.
Obligement. Much of.
May I please your lordship? Lordship, I beg to mention one criminal revision petition, lordship. Next week, any week.
Huh? 27th. 27th. Okay.
May I please your lordship, I would like to mention item number 23. John for the day, as the Angus Council is out of station. The
Yes,
interim
council is?
out of station.
Yes, what about 23? Are they are in interim or no?
Interim order.
Interim.
You are an interim.
Absolutely.
Petition.
May fixed on first week of March.
CDP rating till next date of listing. 10th of March. CDP rating, yes. For written CD. Interim be continued till next date.
May I please, my lord? My lord, I beg to mention item number 3, 4, and 5, my lord. There are, my lord, 6 cases, my lord. Out of, my lord, same party and same out of the same circumstances, my lord. But 3 listed today, my lord. 3 are not been listed yet, my lord. These 6 along with, my lord, listed, my lord, any other date, my lord. And remaining 3 number is CRP number 80, 81, and 82.
CRP 80. Criminal division.
Yes, my lord.
Criminal division.
80, 81, 82.
80, 81, 82.
My lord.
All are 2026.
Yes, my lord.
Mr. K.M. Hassan, the learned cost. 3, 4, and it submitted that 6 numbers of criminal representation filed by the parties, and accordingly prayed that these matters may be listed along with criminal revision petition number 80, which represents 26, 81, and 26, and 80. Please step up.
May I please your lordship? Lordship, I beg to mention for listing of withdrawn, my lord. That is a criminal revision petition, my lord. My lord, tomorrow may be fixed, my lord.
Tomorrow? We are not fixing any case.
Monday, my lord.
হেৰি এইটো মানে কৰাই দিম। কাম
May I please? Doctor, I beg to mention item number 34. Doctor, in this case, CD not received. 34. Doctor, I am not in interim lordship, a short date may be given.
Second, my lord, 2nd of March. My lord. Second. Okay. No. Fully.
Then keep
Then
you.
well, this.
Yes, sir. So on second I forgot.
6th.
Okay.
Please, your lordship, this is the anticipatory bail application connection with an unregistered complaint lodged by the Basu Karmakar before Ambari police station, lordship. The background of the cases is lordship, the police personnel continuously calling the petitioner to appear before the Ambari police station. One time he is appeared, and that time I mentioned that para number 4, page number 3. Have a look. May I read the background of the matter, lordship? The petitioner, about 11 month back, lordship, the petitioner jointly started a wood business with one friend, namely Basu Karmakar, who is a complainant, lordship, where the petitioner invested 10 lakhs and the Basu Karmakar invested the 17 lakhs, and then mutually agreed between the parties that profit sharing would be 40% and the petitioner 40% and 60%. No agreement was ever made that petitioner would solely bear the losses of the business, lordship. That subsequently, when the business incurred losses, the Basu Karmakar started pressurizing and coercion and illegally forcing the petitioner to bear the entire loss, lordship. And hence, in this regards, petitioner already approached before the Ambari police station to lodge one affair, lordship. But the Ambari police personnel has not lodged any affair, lordship, against the Basu Karmakar. One day on lordship 8/1/26, the Basu Karmakar with an ulterior motive and as a counterblast lodged a false complaint against the petitioner. Thereafter, petitioner received the call from the police station lordship, and that time he believed that his own complaint was being taken up. However, he reaching the police station, the Basu Karmakar was present, and in convenience with the police, forcefully obtained petitioner's signature on a black check lordship. I'm mentioning the check numbers lordship. In this regard, I'm also file a CR case before the CGM lordship. Then after lordship, that case already pending. Then after again, police personnel calling to the petitioner lordship appear in this. In the meantime, if he appear before the police station, maybe he is apprehended lordship. So one protection may be given lordship.
There is
And
no case, such case.
Registered complaint, Lord.
Okay, and
maybe
there is
one
no such case. No such case is there.
Mm.
Your main contention is that there was a monetary between the parties.
Mm.
And if there is any, then it's okay. And otherwise also you put signatures on some checks. On some checks. That much only. Why you need anything? Maybe police may the complainant may in connivance with the police may take your signature in some blank checks. But with those blank checks, most probably they may file an NIA case at best. Wherein you don't need such kind of protection. Anyway, we are calling for the report. It is from Ambari Police Station, Gauhati. Ambari Police Station. Which was in Ambari Police Station? Ambari Police Station is nowhere. Is Fatasil Ambari or Ambari?
I think Fatasil, Lord.
Ambari is not there. Pardon me, escape. Done it. Mr. K.K. That's it. Done it. Additional people. Everyone. Section 480 PNSS. Being for candidates. Stating that there is an apprehension of rights of the present use petition in connection with the case which may be solved by one Basu Karmakar or said Ambari next Mr. He will take instructions into the additional people thereby asked to take instructions of the report from the Fatasil Ambari police station. Any case has been registered against the present petition in the same police station. When it can be listed?
27 to Lord.
much obliged.
May I please, Lord?
Yes.
My lord, the petitioner has been convicted by the Lorded Trial Court in NI case, my lord, and he has been sentenced to for a period of 5 months and to pay a fine of rupees 5 lakhs, my lord. In default, he has to go further period of 6 months, my lord. On the trial and against which he preferred an appeal, my lord, before the session court, my lord. That has been also dismissed, my lord. Upheld the judgment, my lord. The check amount is rupees 4,07,000, my lord. May I approve, my lord? Notice may go at this stage, my lord, and it is may be allowed to remain on previous bail, my lord.
You are Mr. Hawari?
How are you, my lord?
Pardon, Mr. A. Petition. Since it has been already 17 passed by learned session judge Dibrugarh in criminal appeal number 35 3 of 2020 and thereby affirming the judgment and order dated 26/07/2024 passed by learned CGM Dibrugarh in NI case number 160 of 18 and thereby sentenced to undergo SI for a period of 5 months and to pay a fine of rupees 5 lakhs with default stipulation. issue notice to the respondent.
Sole respondent.
Sole to speak with and I did also for the DCR. This matter according to the court. I is for
I
stay.
for suspension of
DNS process solutions and additional sessions as approved by Assam Tribunal Appeal number 53 of the right the center. We can say economic sources. Is any warrant has been issued against you? Till
no,
date?
my lord. Till today, no, my lord.
You are still on
Yes, yes.
the execution sort of operation of sentence passed by the Internet report as well as the Internet court of CGN. The state of the suspended till disposal of and there the petitioner may be allowed to remain still till the disposal of suits. Considering the submission made by the counsel for the petition, the present application, the provision of judgment passed by confirming sorry affirming the judgment and order passed by the CGM in an case number state of till the disposal of the connected revision petition, and the petitioner is also allowed to remain on his previous bail till the disposal of observation the IS
Obliged.
Please.
May I please your lordship, my lord? Here, my lord, I am coming with a limited prayer, my lord. The maintenance pendant light has been granted, my lord, from the date of filing of the application. My lord, my prayer before your lordship, it should be given, my lord, from the date of passing the order. Because, my lord, as per 125(2), as per Rajnish versus Sneha's husband, you have to give the special reason for granting the maintenance from the date of my lord application, my lord.
No, it is maintenance pendant light. I think.
Pendant delay, my lord. That is why I am submitting, my lord.
No, then why does this there? It is maintenance pendant light.
Pendant delay, my lord.
Expenditure and the thing will be covered up.
May I coming, my
If
lord?
it is by from the date of order, then how?
I am coming, my lord. Let me allow to submit, my lord. Lordship, first, my lord, I am going to the facts, my lord. Thereafter, I shall go to the law, my lord.
Brief.
Lordship, yes, my lord. My lord, whose fault, my lord, delay took place, my lord. Lordship, kindly come to the page 95, my lord. Order passed by the Honorable Court. The law is that when you file the petition under section 125, you have to file asset and liability along with this application, my lord.
Maintenance pendant light or maintenance? What do you say?
Pendant light. Maintenance order has been passed. Maintenance pendant light, my lord. That
how?
interim maintenance has begun. The final was not decided, my lord. Interim maintenance.
Pendant light is
interim maintenance. Interim maintenance has been granted for the my lord child 10,000 and for the child 8,000 or for the my lord for my wife it was 10,000, my lord. And there is no special reason has been recorded for granting this maintenance. And because I am submitting before your lordship is there, your lordship kindly come to page 95, my lord. The law of the my lord land is that, my lord, along with the 125 petition, you have to file the asset and liability. That was not done in the instant case, my lord. Subsequently, what happened? On subsequent date, my lord, I appeared. I immediately, my appearance, when I got the copy, I filed also WS. Then you also filed the, my lord, asset and liability. He filed asset and liability, I filed asset and liability. Her asset and liability, she disclosed something, my lord, that she has some income, e-rickshaw and other. That was withdrawn. Subsequently, again she filed an asset and liability on next date, my lord. Next date, not next date. After 6 months, I am going date one by one. Before that, I am coming to 6 months. Then, my lord, when she filed this asset and liability, there are more discrepancies. He has made some false statement or oath. And when I served the copy, the Honorable Court is not allowed to, my lord, file this 340 petition, my lord. Again, withdraw allowed her to withdraw the assessment liability, and I was not allowed to file 340 petition. Then, my lord, what happened? Again, he filed the asset and liability after looking my asset and liability, my lord. I have filed asset and liability after
4 months of withdrawing.
after 4 months of withdrawing, my lord, she again filed the asset and liability, meaning thereby after 4-5 months, my lord, of my asset and liability, she filed the asset and liability. And from the date of application, 1 year,
19 months.
after 19 months of the filing of asset and liability filed by the respondent. The law said you file simultaneously or at the time of filing of the application. That is why I am submitting. And when the maintenance has been given, there is no special reason has been recorded why the maintenance was given from the date of application. I am relying on judgment of the apex court. Lordship, kindly take this matter. I am coming one by one. Para 66, madam. Page 368. Lordship, para 66, madam. 65, madam. Party claiming maintenance cost of a partner. মই যাই আছো নহয়, মই কেছ কৰিলে মাজত মাত নিদিবা না, মই একদম কেছ নিয়মত কৈছো. The party claiming maintenance cost as a partner in delivering common law and affidavit discloses liability before the court as a matter on the basis of pleading filed by the both party. Affidavit of disclosure, the court would be in a position to make objective assessment approaching amount awarded. 66. In Kusum Sharma, you will say directly come. The court take notice that filing affidavit along with pleading gave an unfair advantage to the party who filed the affidavit subsequently. In the judgment, it was clarified the affidavit must be filed simultaneously by both the parties. In Kusum Sharma, the court considered the format of affidavit in the previous judgment directly above. Then, my lord, your lordship directly come to the page 669, 72.1. The affidavit of disclosure of asset liability annexed to enclosure 1, 2, 3 of the judgment as may be applicable shall be filed by the parties in all maintenance, including the pending proceedings. The applicant making some claim for maintenance will be required to file concise application accompanying affidavit disclosure. Then your lordship come to the then my lord 72.8, 370 page. The pleading made in application for mention and reply should be filed responsibly. If false statement misrepresent may consider the proceeding. Then your lordship, I filed a 340 petition and that was not allowed to my lord, and he has received the copy. This is there.
Now you are agree with the interim maintenance.
Interim maintenance.
Now what is your prayer?
My prayer is small, my lord, because maintenance is necessary. My lord, I have given the fees of my daughter, my lord, from the day she has taken admission from the school, my lord. I have paid to her, my lord. But in respect of, my lord, maintenance, the law is that maintenance is generally made from the date of order. My small prayer, my interim maintenance shall be allowed to give from the date of order, my lord.
Without hearing understand, I won't pass you.
I'm coming 1 point, my lord. B, my lord, 101B. I'm on law point, my lord. Page 370.
To hear the other side. That's what I'm saying. Yes, there is a law. Assets and liabilities has to be there.
Yeah, my lord.
Everything. Now we are issuing notice at this stage. And if any interim prayer is there from your part, that much only you can do.
Interim is very small, my lord. I shall pay the maintenance from the date of order, my lord. That is my pay. Because you know, 377, only for 1 second, my lord. From the date of order, 102, the second view that maintenance ought to be logically look to be awarded from the date of order based on premises that generally is to award maintenance from the date of order, and grant of maintenance from the date of action must be in exception. General rule is that you have to pay the maintenance from the date of order, and that is the exception. The foundation of the view based on interpretation 125.2 CRPC, which provide 125.2 has been mentioned. Just next, my lord. The word or if so order in 1625 has been interpreted to mean that where the court is awarding maintenance from the date of application, special reason ought to be recorded. There is no special reason. I want to see your lordship. Just kindly look to that, my lord. Delay took place on her part, my lord. Lordship, kindly come to the 106, my lord.
And then we treated on it.
106.
The then CRPC against a impugn ex parte order dated 5/01/2026 filed by the learned Principal Judge Family Court number 1 in FC criminal case number 102, directing the applicant to pay an amount of 10,000 per month to the respondent wife and rupees 8,000 per the child from date of this is interim or final order?
Interim order, well, that is why I am submitting.
5/1, no?
Yes, madam.
You have this order on this 95 page number.
Page number, my lord, 106, my lord.
Page number.
And last part 107. The opposite party is directed to pay 10,000, 8,000 per month, minor daughter, and interim monthly maintenance for the date of filing of the case. But no reason has been given. Why this is not given?
Notice to the sole respondent to speak post and within for the scan copy. Further, it is submitted by Mr. Chaudhary that the interim order was granted without considering the access and liabilities of the parties, and considering the fact that the petitioner, the respondent failed to file her access and liabilities with the petition in the file submitted to that by against the which where it is not within as per the guideline passed in case of Justice versus State. Further, it is submitted that the date of the order has been filed from interim maintenance order has been filed date of filing without assigning any special reason. Accordingly, he submitted that further. So you want to stay that order?
I
What
don't
is your
want
interim
state up. Only that part. Date of application. I want that. I say will the maintenance from the date of order.
No, we are not passing we are not disposing the case at this. What is your interim prayer? Is there
My-
that's what I'm asking.
My prayer before your lordship is that, my lord, as per law, that yes, yes,
okay,
sorry, yes, yes,
law
yes,
is okay, I can
from the date,
understand. Let
yes,
them
ma'am.
hear the
From the
matter.
date of order, I shall pay the maintenance, ma'am.
Huh?
I shall pay
Then the
the,
entire petition will be disposed of.
yes, my lord.
How can? No, we cannot.
I want to not dispose in the interim.
Now see, in the interim only, they have submitted that from the date of application, you are supposed to
Yes,
pay the interim maintenance.
yes, my lord.
Now you are saying it is not as per law, as per not as
Yes,
per
ma'am.
Rajesh and but there is no special reason
Yes,
has been assigned by
Yes,
the
ma'am.
learned principal judge.
yes, ma'am.
That much your submission.
That's
Now
my
you are
submission.
saying that I am agree to pay from the date of order.
Yes,
But that is your petition itself. It is your petition.
yes, ma'am.
So if I pass the order, the date of order, then enter petition will be disposed of. I'm saying whether any prima facie, any interim prayer is there.
That
If I
is-
pass the order that you have to pay the maintenance from the date of order,
That's
then
fine.
your entire petition will be disposed of.
Not my lord.
Then
My pair is that, my lord, as per pair before my petition is that order may be stayed. Your lordship kindly go to my prayer person.
yes, I have seen.
Yes, my lord. I am not praying on that my lord. I myself reform this, my lord, prayer, my lord. My prayer is that, my lord, in the interim, your lordship has directed to pay the maintenance from the date of order. If tomorrow other party had come, if your lordship think that the maintenance should be paid from the date of application, then that can be done, my lord. And if I am not getting the order, my lord, then, my lord, my petition will become infructuous, my lord. That is why I am praying before your lordship.
No, see, Mr. Chaudhary,
Yes,
your
ma'am.
petition is that
Yes,
your petition is that the order passed by the learned principal judge is a wrong
yes,
because it is not as per the guideline passed in by Supreme Court,
yes, my lord.
Brazil versus Seha.
Yes, my lord.
Isn't it?
Yes,
And there is no special reasons has been assigned while
Yes.
passing the order,
yes, my lord.
and it is simply passed that order that the date of application you have to pay. You
Yes,
have agree on that order, isn't it?
Yes,
Now
my
the petition is there. You are still saying that we are ready to pay, but not from the date of application, but from the date of order.
that is my lord.
If I pass that order, your entire petition will be disposed of today without hearing any other side. That's what I'm saying.
No, I am not saying, my lord. Your lordship kindly go to my
Okay,
prayer.
issue notice. I have done it. Issue notice.
My lord,
I'll
kindly,
be fixing a very short date so that it can.
my lord, your lordship can pass that into stay, my lord.
What?
Or that order is wrong.
Ah.
So that may be stayed, my lord.
Stay.
Yes, my lord.
In we generally never stay. I never stay the in maintenance order. I never stay.
That
By
is
this
why
court, I never stay.
your lordship has the correct, my lord. Your lordship is not granting stay. That is why I am only modifying the order, passing that only that part, date of application, only date of
That's
application.
what I'm saying. Your main grievances is the date of application, isn't
Yes,
it?
my lord.
Not date of order. It should be date of order.
Yes, my lord.
If I pass the order on date of order, then your entire application will be disposed of today only. That I'm not going to do.
May I read the prayer portion, my lord? That,
read.
yes, my lord. Para 22. My lord, may be graciously be to direct the respondent to pay a sum of rupees 75,000 per month in the said respondent monthly maintenance or at such rate. Sorry. Page number 12. Yes, my lord. In the premises aforesaid, your lordship may be pleased to admit this petition calling for the report issue upon the respondent to show cause a why impugn order dated 5/1/2026 passed by the Court of Principals Family Court in FC should not be set aside to us. This is my main prayer. And upon causes being so please set aside so and so pending disposal of the rule. Operation of the impugn order 5/1/2000 in FC case number so and so passed by principal, thus family code number may be stay kept in the bench. That is my prayer. That order, because this is against the guideline of Rajneesh and Sneha, so that may be stayed. This is my prayer before your lordship, my lord.
That is not allowed by this court.
Yes, my lord. That is why I am submitting before your lordship that my petition will be not, my lord, allowed. If your lordship has passed that, I shall pay the maintenance from the date of order. And for the date of application, I have shown due to her conduct, it could not be given. So it should be paid date of order till the appearance of the respondent, my lord. Let them satisfy.
Sorry,
That
we are
is-
listing it then your pet list accordingly.
That is small prayer.
We are listing a very short date. We are as much as we can, and 11th of March. Then only one date will go, I think, in that case. Let them appear, we'll dispose of the entire matter. Only
My lord, till that date, my lord.
sorry, your entire petition will be disposed of.
Till that day, my lord. I am asking for that. Otherwise, my lord,
Now,
next
see,
day to think.
I'm just speaking repeatedly also. Your only grievance is that it should be from the date of order, not from the date of application. If I pass the order, that is the main grievance. That is the main grievance. Isn't it?
No, my prayer is that order may be stay, my lord. But my lord, next date is 3, my lord. If I not paid, my lord, I face the consequence, my lord. That is why I am
Yeah,
praying
11
for.
and generally I don't pass any stay order. 11-3, especially in these cases. 11-3.
Warrant shall be issued against me, my lord. It was fixed on 3.
11-3. And when it is fixed,
I shall take dusty service. It can be my lord.
when it is fixed, your next case, your other case,
5-3.
Ah.
That it may be fixed on 3, my lord.
3.
Yes, my lord.
3-4 is a holiday.
2, my lord.
Okay. 2-3.
2, my lord. I shall
You
take
have
the
to,
service.
you have to, the notice has to be served. Huh?
My lord.
2nd of March, if you can, then it's okay.
I shall take the dusty service also.
Dust is generally not allowed. It is a criminal case. Let us see. You just try it.
Here, my lord, I have challenged the rejection of my Jimma petition, my lord, which is at page number 60, my lord.
Your Jimma prayer was rejected.
Rejected. Only my fear is that, my lord, one Scorpio, my lord, and that may be damaged, my lord. Only prayer is that, my lord, I will be allowed to maintain during the interim, my lord. Otherwise, it will be damaged.
Where is the vehicle?
Hello?
Vehicle is at police station?
Yes, my lord.
Then how you will maintain? In the police station, you are going to maintain.
Yes,
In
my
what
lord.
manner?
Otherwise, it was damaged. But
In what manner?
How?
How? Tell us how.
Cleaning, my lord, and other thing, cleaning or starting, my lord.
So without any order also, you can go for cleaning. No issue. No issue.
If they
we are calling for a report.
Hmm.
Let us see if it can be finally disposed
Man.
of, if matter can be disposed.
Then that may be fixed, my lord.
From where from it has come?
It is running. Polasbari police station, Polasbari, but it was given in Rani, my lord. Outpost is Rani.
Precedent education. PNSS, railway station, PNSS. Stay the GMFC. Dated 3-1. Let the report be called for from the concerned I. Additional people will do the need test the matter of anything.
5th March. 5th of March. Other
Let it be on
6 hours.
Lots of matters are
Okay, blood.
They're listing it on 6th of March, and unofficially I'm telling, if you want to clean and all for your, you can go for. Talk to the IO or the police.
Now, whether allowed or not, that is the issue, my lord. Highly obliged.
Lordship, this petition is filed for setting aside the order dated 26/11/2025 passed in CR case number 378 of 2025 by the Judicial Magistrate First Class Hailakandi, which is passed absolutely in abuse of the process of law, Lordship. Kindly I would attract attention of the Honorable Court to Annexure 5, page 32 and 33. 33 and 34. Lordship, in the last that is 34. Hence, accordingly, cognizance is taken of an offence under section 109, 115 within bracket 2, 117 within bracket 285 and 34 BNS. Now, 109 BNS is corresponding to 307 of the IPC, which is attempt to murder, for which there can be punishment up to life. And it is triable only by the Court of Session. And it is in a complaint case, the learned magistrate takes cognizance of a offense which is triable exclusively by the court of session. Then the other things, the lordship, on going through the complaint petition and the two examinations that has been done, initial depositions, lordship will see that neither of the matter, any of the alleged occurrence has taken place within the district of Hailagandi. All the allegations are either in Silchar or in Bangalore in the state of Karnataka. That is the second part. But primary concern, which vitiates the entire order of cognizance patently, lordship, is that the learned magistrate has taken cognizance under section 109, which patently makes it clear that this is an abuse of the process of law. There can be errors, your lordship, but when the error is with regard to the judicial powers, a magistrate can take cognizance up to offense of 7 years, takes offense under of offenses for life imprisonment, that becomes vitiate. Under section 224 of the BNSS, lordship, what should have the magistrate done in such circumstances is to
What is the section?
show the 224 of BNSS.
284.
224 of BNSS. Procedure by the magistrate not competent to take cognizance of cases. If the complaint is made to a magistrate, if the complaint is made to a magistrate who is not competent to take cognizance of the offense, he shall, if the complaint is in writing, return it to be it for presentation to the proper court with an endorsement to that effect. If the complaint is not writing, direct the complainant to the proper court. So the entire procedure has been laid down in the procedural law, lordship. But the allegation in the complaint is also in that regard, and the learned magistrate has taken cognizance of that. That completely vitiates the process of law, lordship.
How he will commit the case? There is no such order that the learned magistrate is going to try the case, because for committing an offense also there has to be.
Before committing a case, cognizance is not to be taken, lord.
Then how, on what section it case suppose affects, how he will
if the court is not found, then it is to be in accordance with section 224.
No, how without coming to any conclusion, how the court will send the case?
The case record is to send to the.
Send means committed. It has to be committed. How?
Yes.
How he will commit?
Under the original 293 and presently 210, as only the court of sessions can take cognizance in sessions tribal cases.
It's okay, but how he will send the case now? Because after recording, say, the case of the, I mean, under, I don't know now it is, what is the provision? Earlier to the 200 to 202, these were there.
Sure.
So at the time after recording these and things,
No, that is why the procedure has been provided.
We'll make the mind that this case
That is has been the procedure is provided in section 223. Lordship, then notice will be issued, provided that no cognizance to 23 first proviso, lordship. Provided that no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard.
Now it is not.
Yes, there, if the procedure would be, if
so you appeared before the.
Yes, we have appeared.
Then
the record is to be transmitted to the sessions.
No, how? Without, I mean, on cases under which section? Now court has to be there has to be some reason. Otherwise, how it will be committed to the court of sessions? Tell us how it will committed, because the procedure is followed under 223. Notice was given to you. You are heard. Everything was there, and then only cognizance taken. Then it will be committed. Now, otherwise, how? On what basis it will be committed?
In compliance with 224 lordship, in compliance with 224,
224 is not there. 224 is different. There may be some judicial issue, other issues are there. That's why if the magistrate is not competent at all in that case. But how? You just tell me how it will be committed. It has to be committed to the sessions court. How it will be committed? Yes, does anything?
My submission is, Lordship, is that for committing a case, even if we take the government cases, before that, cognizance is not taken.
There are the charge sheet are there, na?
Yes, a charge sheet is there. Charge sheet is there, but no cognizance is taken.
Obviously, this charge sheet is there, na?
Charge sheet there, not cognizance is taken. So before taking
The magistrate is not supposed to apply his judicial mind, etc. and etc. because charge sheet is already there. But now how? I'm just asking you. I may be wrong, but how we will commit?
this
How we will commit the case?
on the basis of the complaint and the depositions that are there.
Yes, anything.
On the basis of the complaint and the depositions that are there, if it is exclusively triable by the Court of Sessions, it will be then and there committed to the.
Is there anything there? Can you show us any in that regard? Anything is there? How what is the procedure? How we will commit? Without coming to a conclusion that this case is of session maybe there, maybe 302, maybe whatever. How? Yes.
Lordship has taken the right view, Lord.
224 is different.
Lordship, it's a different thing. How it can be committed?
The question here, Lordship, is once cognizance is taken, she is to try 109. How can the court try 109?
Punishment.
Give a punishment for life imprisonment.
She cannot try. He or she cannot. Magistrate cannot try.
That is
just asking how he will commit.
That is not been done later.
How the magistrate will come to a conclusion. That is the session tribal. How?
Yes, from the complaint and the initial depositions that are there, that would that is the basis on that is the basis on which a decision is to be made.
To be there, na? An order has to be there.
Yes, after the initial deposition, it can be sent.
No, where is the procedure? So show us after initial deposition how it can be.
No.
Yes, sometimes it happens that the case may not be there. Then it is the order may be there for investigation to the police station.
Yes,
that is there. That is there.
That is there.
And moreover, the jurisdictional issue is also there for Hailakandi and
the So, Lordship, apparently there is some errors. And my
asking you, what are the errors? What apparent errors? I'm not following you.
Lordship, that cognizance has been taken for regarding what first of all
with the order of cognizance, because there may be the materials may not be there. Everything then will be there. You may agree with the order of cognizance.
Materials are not absolutely there. Materials are not absolutely there because
you can
because it is yes.
Procedure.
The case is filed in Hailakandi.
23 is also complied with by the
yes.
magistrate.
Yes.
You are given an opportunity of hearing also by 223. 224 is different.
As Lordship, on perusal of the complaint as well as the initial deposition, it is.
If you make some research on that, we are also going to see what is the other procedure. I'm not. What is the trial going on? How it is proceeding? I'll also make an answer.
Lordship, till that a stay may be granted.
No stay. We are not complying with any house taken. It is only summons were issued to you, I think.
Yes, summons.
We're listing it very short date. See. Okay. You are supposed to appear on which day? Next date is listing?
On 6th March.
6th of March. Second. We're listing it on 2nd of March.
Lordship.
2nd.
Record may kindly be called.
No, we are not passing any. We're listing it on 2nd of. You just give us if you have any procedure. We also make a recharge on that.
Yes.
May I beg your lordship? So this matter pertains to quashing of GR case number 9010 of 2017, which is pending before the SDGM 2 lordship. Here the
SDGM 2.
petitioner and respondent number 2 were got married in the year 2015. And due to some differences and disputes, the respondent number 2 has filed several cases. But in 2019, they get mutually separated by certain conditions, lordship. May you please peruse annexure number 2? The terms and the conditions, page number 18.
Yes, which page you see?
Page number 18, annexure 2. This is the final order of their mutual divorce. And the condition is the respondent has already withdrawn the other cases and to take necessary steps forwarding withdrawal of the all women police station case number 120 2017. Lordship, but this
final
case has not been withdrawn by respondent number 2.
Just family. This was the divorce case.
Yes. And after that, respondent number 2 has already got married, lordship. But the case is still pending before the SDGM 2. Charge sheet has also been filed. And the petitioner is at presently residing in Bhopal. So it is not possible for him to travel to Gauhati. And also he has been continuously visiting lordship, but respondent number 2 has not yet visited even a single date, lordship.
She has to receive summons and
No,
it is only charge sheeted.
Yes. And
After charge sheet, charge has already been framed or not yet?
charge has framed, lordship.
Charge has framed?
Yes.
Then notice, if notice go, then she will appear.
BWA also been issued against the respondent number 2 also. But she didn't appear. So, and the next date in the lower court is tomorrow, lordship. So kindly the matter may be stayed as the petitioner is residing in Bhopal.
For watching the all of case number 1017 corresponding to GR case number 9010 section 14 pending before the court of SDGM S number 2 Bangkok M. Issue notice to response. Formal notice is required to be submitted and will be petition will be submitted. Most of all, the scan of next Ms. further submitted that before filing, no, after filing of the present fire, the matter is amicably settled between the parties, and there were many cases between the parties which were already been settled, and one final order was also passed for their the final order was also passed in FC civil case number 370 of it, dissolving marriage between the parties. But after the filing of the charge sheet, petitioner, the respondent is not appearing for the so the matters are being kept separately. For the say for stay of further proceeding. Let the further proceeding case number 20 state till next state listing estimate.
Lordship.
My lord, we have filed this case for crossing of FIR and subsequent proceeding on the ground that husband and wife have amicably settled the difference. Both husband and wife have appeared are before your lordship, my lord.
Jointly filed this petition.
Jointly filed petition, my lord.
Case has already been charged sheeted or not?
This is charge sheeted. Next date is on 11/6/26, my lord.
One is husband.
Husband and-
And who is Sunita Hazarika?
And my lord, petitioner number 2, Sunita Hazarika,
Is the informant.
she is the informant.
Now they are staying together.
Yes, yes, together.
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 She also put her signature in Vakalatnama.
Yes, and also there's affidavit also, my lord. Affidavit, we have filed 2 affidavit in this case. One is by husband and another is by the wife, my lord.
One is by husband.
Husband.
And one is by
Wife, my lord. Page 13 is the signature of the wife in the affidavit, and page 11 is the signature.
From that, is there any other compromise petition or compromise?
No, we have not made any separate agreement. We have directly approached this honorable court and filed this case.
And the case is charged sheeted under
Case
section
is charged under 498. 498.
Yes, law for it.
Yes, they have amicably settlement.
Family matters. Third, Mr. I. Chaudhary, the learned counsel of the petition. Mr. P.S. Thapa, the learned petitioner PP, bring on and section 528 PNSS for setting aside and quashing of the entire criminal proceeding, which is pending for the Court of Learned in connection with PRC case number 942 of the and section 498 IPC and the FIR and charge sheet all women police station case number 258 of 2021 and the charge sheet number 15 of the 2022. The petition is filed jointly by the informed victim and the accused of this case, who are the petitioner number 2 and 1. It is submitted by Mr. Chaudhary that after filing of the FIR, due to some differences, the FIR was filed by the petitioner number 2, but before filing of the charge, matter has really amicably settled between the parties, and at present they are staying together. The victim of the petitioner number 2 the one the case further, and accordingly this petition has been filed jointly by bring for the quashing of the including the FIR And even if the case is further, there is the conviction, the very conviction, chance of conviction is very big and different, as the victim from it will not depose anything against it. Rather, petition number 1, rather it will be an abuse of process. Accordingly, is submitted with the criminal proceeding as well as the expenditure set aside and quashed by invoking power under section 5. Yes. Next, Mr. Kapoor that is testimonial by the both departments elaborated and consent. Next, state has no objection if the criminal proceeding and the FIR charges was okay, it will
Absolutely.
Well, Lordship, pass over the matter for time being.
May I please, your lordship, kindly pass over the matter for the time.
name subsequently it will come or not, I cannot say. Okay.
May it please, my GIMA application was rejected. GIMA application for my vehicle and my bank account has been freezed because of a case, my lord. And the impugn order is at page.
Impugn order is at page?
No, I'm taking it also. Page 16. 16. Next page, the impugn order. Next to
So it was your petition was rejected. So now you are seeking only the vehicle or
both. I'm seeking both.
Yes.
And here, Lordship, that order was 12/1/2026, my lord. Then Lordship may call for a report from the IO, my lord, regarding the whether it is required or not for further, my
do you have any information whether case has already been charged?
Because, my lord, because I am on an interim bail, my lord.
No, it's okay. You're on
Not,
bail.
but
Whether
the
case has been charged.
No, madam, because today the case anticipated bail was rejected and the CD has not come. That was the submission given by the PP in the High Court. So CD has not come. Interim order.
You are on interim.
Interim.
That means CD not.
Not
The charge sheet is not.
Not by.
Part Mr. P.K. Roy Choudhury, the learned counsel for petition, also part Mr. B. Sharma, learned petition. PP, appearing on application section 528 BNSS, praying for release of seized articles, public vehicles, public mobile phones, GIMA, to the rightful owners and the freezing of accounts of the petitioners.
Vehicle. That I hold one Innova Vista, one mobile, one account.
My petition was the learned JMFC Boko Kamru by its order dated 12/1/2026. Mr. Sharma, the learned petitioner, the report may be called from the concerned investigating officer as to those articles required for investigation. Let the report be called for. When it can be fixed?
Well, 11th of March.
11th of March. Let the matter be according to this. Next is also your, I think.
My lord, and the same case. Same case.
Same case.
Same case. Two vehicles, two owners, separate owner. Separate.
One is one
Scorpio, one is the Innova.
and the other is
Innova.
for us Moni Das.
For us, Moni.
Okay, same we are listing it on both the matters on 11th. একে হবে, খালি আপনি
Let the matter remain tagged together, my lord, because the report is self.
Page is also further directed to take the case record here in action along with criminal petition number 236 of it. It will attack with.
Obras.
Head lordship.
Asking for his state is there or not?
No, it's CA case,
Acha, see,
complaint case.
complaint case. Yes.
And difficult to understand on reading of the complaint, how a criminal action be taken against all these persons. Here, the accused member is a society, and others are the executive members of the society, and two chartered accountant also here. Now, basically, at this stage, my humble submission before this honorable court is that the learned magistrate has committed a wrong by issuing a notice on receipt of the complaint under section 223 of the BNSS without examination of the complainant and witnesses.
Not examined.
Not examined. That's a wrong. On the very first day, issue the notice under the provision of 223. My lord, the judgment by this honorable court is a settled position now. Unfortunately, that judgment was circulated to the district court, my lord. I argued the case before Lanet's coordinate bench, and I requested the coordinate bench, my lord, to circulate this. Just because in some of the district, my lord, some of the magistrate issue notice without examination. Some of the magistrate, after examination, issue the notice. So therefore, there is some confusion amongst the judicial officers in the state. So these judgment, my lord, elaborately discussed.
If suppose notice is also issued in that case also, but you will give enough opportunity of hearing, or that was also not.
In this case, my lord, which I placed before the honorable court, the similar fact that after receive the complaint, straight away issue the notice without examining the complaint. Now that we challenge before this honorable court. And after discussion, all the High Court judgment, my lord, this honorable court, coordinating bench of this honorable court held that the examination of the complaint is mandatory before issuance of the exercise the power under section 223.
Because after examination may not.
Because after examination, my lord, the 226 will come. The London magistrate may, without issuance notice, may dismiss if there is no prima facie case. So the mandate of the law is, my lord, that this judgment, lordship, may kindly have a look at 16, 17, and 25 of the coordinate bench, wherein all the High Court's judgment till today, my lord, has been discussed by this court. Because 223 starts with the word examination of complainant, my lord. So in fact, my lord, this judgment, if circulated to the all the, then may not be this revision application may not come before this court. Para 16, 17.
Examination is
mandatory, madam. Without examination, you cannot issue the notice straight away. Because after examination, my lord, the learned magistrate can verify the entire things and came to a judicial finding that yes, the case is itself not maintainable or no prima facie case is made out. So therefore dismissal. If learned magistrate has came to a conclusion that no, there is a prima facie case, then issue a notice and heard, the cognizance stage. And then cognizance may be taken.
order, impugn order.
No, page 35, madam. Page 30, last page, madam. Complaint case record is received on transfer from learned CGM for disposal under section such and such. Peruse the case record, complaint is present. Considering the above, this court deems it fit to issue notice.
Lordship in 2A, Lordship may subject to correction, my lord. They either dispose the entire matter, my lord, directing in view of this judgment, directing to take complaint and then decide whether there is to exercise 226. Thereafter, Lordship is issue a notice and giving us a liberty. If then the conclusion is taken, then we came before this court. It is always open. Or otherwise, stay the proceeding and then issue a notice. That's that. Either this way, my lord. Lordship may take.
I don't know whether it is on the basis of the complaint. Suppose there is that app cannot say at this stage on the basis of the complaint or the statement made in the complaint.
Absolutely correct, my lord.
Maybe I don't know, but
because statement is necessary to whether this statement and the complaint is supported by the witnesses.
Obviously, that has to.
That's the essential prerequisite, my lord. I am just adding the earlier one matter. Atlantic Council was argued before this court. I'm sitting there, my lord. So that the issue is this 220, that 231 or this earlier 209. Now BNS is very difficult to remember, my lord. We remember the CRP 209. In 209, my lord, that if it is session tribal case, then after taking cognizance, this has to be committed. Before taking cognizance, cannot be committed.
Anyway, we'll do one thing. We'll stay the proceeding.
Oh, my lord, my lord.
And we'll issue notice.
Yes, my lord.
Obviously, prior your submission is correct. I have seen the provision also.
Yes, ma'am.
Examination of the complaint is necessary. But let them appear, we'll see to it.
What I also, being lordship is on the other is all control this district judiciary, my lord, is on the bench. So it is necessary, my lord, that just to avoid all this confusion.
That's
yes,
there is thinking. To avoid these complications and all. We'll talk to our people and the registry people.
Yes,
so
my lord.
We can
Yes.
do something.
Your lordship may.
Because if there is a difference between taking cognizance and we have submitted.
From our side, we cannot circulate.
No, your side is fine.
Yes.
We'll talk to you.
As a lawyer, I am happy that that we filed it and appear before this court.
Assisted by here. Assisted by Mr. Hasdek. This is an application under section 5 Spain for preempted proceeding CR case number 06 of 26. Pending before the judicial magistrate first depot court under section 61, 351, 356, 196 PS. Issue to the sole respondents to be post for the scan. Further, it is submitted by Mr. Senior that there is a procedural irregularity while issuing notice to the present petitioners, as even without recording the statement of the complainant, the notice was directly issued by the first order after receiving the complaint by the learned trial. Is subject as part of the analysis. It is the duty of the magistrate to issue notice after recording of the statement of the complaint and take cognizance of hearing the other side. Accordingly, it is submitted that there is a severe irregularity while issuing notice to us. And in view of this, he paid for stay of the quarter in condition. Considering this action made by the departed and included an ATM list recording up. Okay, we are listing it up.
Is it possible on 24/3, my lord?
24. That may be that
24/3.
24th of March.
Grateful, man.
Yes, what is 20?
Certainly.
They are not here.
Not.
An person called for the petition. By this limited time is still unattended. Case has already been charged. ICS number
11/2026 dated 31/01/2026.
the case has already been charged. The petitioner is hereby asked to accept the trial court, which may be considered with the
May please, your lordship. Lordship,
It is not available.
my lord, on the last occasion, my lord, on 13/2, my lord, it was listed, my lord, considering the length of detention, lordship was inclined to grant me bail. But my lord, there's the learned PP, my lord, he has, my lord, sought for the CD and sought for a short date. Lordship has fixed it today.
How, since when he in custody?
He, my lord, since my lord 7/12, he is in custody. Today is my lord 76 days. He's in custody. My lord.
The nature of case?
Nature is my lord 305A, my lord. Theft, my lord.
It is theft.
Theft, my lord. Read with my lord section 331(4). That is punishment for theft, my lord.
305 is habitual, I think.
305, my lord. 305 is my lord 5 years, my lord, imprisonment.
305 small a is
Lurking hostage 3031.
305A, my lord, is my lord.
no, 331 is possibly lurking.
3 is 40, my lord, life in prison. Lord, everything has been recovered, my lord. As per the, my lord, from the accused number 1, my lord. This, my lord, Sanjay Das, my lord. He is the main culprit who has committed the offense, my lord. My lord, and I am, my lord, the Rapido driver at Gauhati, my lord. On the day of occurrence of the offense, also I was at Gauhati, my lord. And police of Dispur police station, they called me and I went to the police station on their call, my lord. And from there, my lord, I was arrested. On the next day, my
You
lord.
have past history. You have past history, I think.
No, my lord, no past history, my lord.
Otherwise, how?
No past history, my lord. Past history is in connection with, my lord, this Sanjay Das, my lord.
90 days.
Sanjay Das is, my lord, and I know Sanjay Das as a police person, my lord, because from this Sanjay Das, my lord, police uniform has also been recovered by police. On arrest, this police uniform has also been recovered from this Sanjay Das. I know him as a police person on duty, my lord. He sometimes hire me for in my Rapido, my lord, for traveling from one place to another at Gauhati. As such, I know him, my lord. And he has committed the offense, and as maybe, my lord, my phone number has been traced from that, my lord, for his phone calls, and my lord, because of that, my lord, I may be, my lord, implicated in the case. That much, my lord. But I, on the day of offense, also, my lord, I was at Gauhati. On that day, my lord, my brother-in-law is also with me because he has come from my village, my lord, for some official works here. He was also with me. Then I was, but I have not committed any offense, my lord. But I know this Sanjay Das, my lord. That I admit, my lord. I know him as a police person on because at 6 Mile, my lord, on duty at 6 Mile, my lord. And sometimes he hire my Rapido. That also, my lord, that he used to do that, my lord. My lord, considering the, my lord, length of distance, my lord, this, my lord,
forwarding report, page 16. নামজন কি আছে মানুহজনৰ?
মোৰ এটা প্ৰজ্ঞান নাৰ্জাৰী।
It is page 16, para 5. Recovery of police uniform from the accused in highly alarming circumstances, Lordship.
This is from this
4 live animation.
Everything has been recovered from this Sanjay Das. These all stolen property has been recovered. Apart from the stolen property, other properties also has been recovered from this Sanjay Das by police. Not only the stolen properties, but the other properties also have been recovered from this Sanjay Das. Because these are, I have seen it, these are displayed in the news also, my lord.
In para 13, it has been stated that it reveals that the co-accused
Aminul Haq and
Imanul
Pragyan
Haq and
Arjay
Pragyan
explicitly
Arjay
stated during their communication that he would wait for Sanjay Das after completion of the burglary, thereby confirming his readiness to assist in post-crime, escape, and handling of stolen articles.
and in 11 also, Lordship, point during investigation, it has surfaced that the co-accused persons had prior knowledge that accused Sanjay Das was preparing to commit theft and burglary, Lordship. Awareness is also there, knowledge is there.
Considering the length of detention, I am 76 days behind, nothing to investigate more, my lord. I have already, and I was in police custody also for 5 days, my lord.
Otherwise, I will pay for colleague CD law.
Yes.
So second, and the list as well as reporting reports have been seen. All the stolen articles from house of one Sanjay Das, the co-accused. He further to that is a fact that sometimes he used to bring the co-accused Sanjay Das, whom he knew as a police officer. So second, but some police information from co-accused Sanjay Das, who is the main as some telephonic conversation with the present the accused Sanjay Das. He got arrested in connection with since last 76 days he is in custody. So continuing with this part the and there is nothing to interpret with the accused petitioner part. Next, Prime Minister Das raised objection and submitted that it is a case where the theft was committed by wearing the police uniform and some live ammunition were also recovered during the investigation. He further submitted from the forwarding report itself, seen that this accused petitioner had a talk with the other co-accused Sanjay Das, and Sanjay Das and cooperated him in fleeing away from the scene. Mr. Das accordingly raised objection and submitted that CD will be recorded to know the facts. Next, during this submission, the annexures panel, including the body, into the other matter case, is seen that after the police remand for 5 days, the petition was never been interrogated by the police, and the IO also got sufficient opportunity to interrogate the present petition, keeping him in custody as he is in custody since last 76 days. So considering only this aspect of this and the petition, whose satisfaction as to
satisfaction of the
was that
Bongaigaon CGM Bongai.
CGM?
Bongai.
Bongai.
Motion.
Supplemental is 45 and 46.
Yes.
May I please, Lordship? My
45.
lord, in this case, my lord, the case that you was called for, my lord, considering the, my lord, the plea of health condition, Lordship. Lord, medical report was called for, Lordship, the judge and Lordship. My lord, the petitioner is, my lord, just a, my lord, contractor, Lordship. As a family member, my lord, FIR was, in the FIR, his name was implicated, Lordship. Actually, the self-help group member was, my lord, the petitioner number one, accused number one, Lordship. On the other hand, Lordship, the named accused, the named accused, Lordship, is on interim bail, Lordship. But I am in jail, my lord, for 49 days, Lordship. My lord, on 7 to 2026, 9 to 2026, 16 to 2026, 19 to 2026, he was taken to, my lord, Nagaon Civil Hospital for treatment for his kidney problem, Lordship. I have also collected the screenshot of the prescription and the medical report from the Nagaon Civil Hospital, Lordship. Herein is the bite, renal ecopathem, Lordship. This is a kidney problem, Lordship. What report was submitted by the
Jail, man. Jail. Jail.
jail? What report was submitted from jail? I don't know, but this is the report from the my medical hospital, Lordship. Copy of the report from the hospital, Lordship. He was examined on production by the, my lord, jail authority. My lord, impression, kindly see bright BL renal ecopathem. This is a kidney problem, Lordship. If the problem is not the why he was taken for consecutive 5 days, my lord, not consecutive 5 days, 4 days in, my lord, hospital, Lordship. Today, it is reported that today, my lord, itself, my lord, he is being taken to the GMC, Lordship, for treatment, Lordship. Now, condition is very critical, my lord, as per instruction, Lordship. At this stage, CD was called for, Lordship. Today, just 49 days, 60 days offense, Lordship. If CD is, my lord, required, that may be called for any date, Lordship. We may be protected by interim order, Lordship. We may be released on interim bail, Lordship, so that we can get proper treatment, Lordship.
There may be some urinary problem, but there is no specific problem with kidney and all. And if you go by your report submitted by you only.
No, this is not my report, Lord. This is from the medical on production, my lord. He was examined by them.
That's what I'm saying. The report which is submitted by you only.
Yes.
There also it is seen that both the kidneys are normal in size, shape.
No, size is normal, Lord.
Just listen. No evidence of any, calculus is also there. No stone, etc. is there. And hyperstosis is noted. Cardiomedullary information is, differentiation is maintained there.
Well, the impression is,
in our report also, ultrasound also done, it was found clear,
Now, there may be some.
Today is 49 days, my lord.
That's what I'm saying, that you are basically emphasizing on this kidney problem. Is not suffering from such kidney problem. He was advised to have some plenty of water.
Other aspect, Lordship. The named accused is on interim bail, Lordship. He is outside, Lordship. I am in jail for jail for 49 days.
Yes.
I have been interrogated, Lordship.
My lord, here Lordship may kindly pause for a moment, my lord. Annexure to my lord.
Otherwise,
Page,
it is the case, in fact.
page 13, my lord. Page 13, my lord. Ground of arrest, my lord. His ground of arrest.
First of all, FIR
Presents against him 87 numbers of FIR against him. 87 number.
I don't know what 87 numbers, Lordship. This is the fact, my lord.
The accused person, namely Sajidur Rahman, with his brother, created a self-help group and collected huge money from public for a term. But before maturity of term, accused person, namely Jahangir Alam and Asadur Rahman, fled away. The accused person, Jahangir Alam, so and so and so, are alleged of expropriating money of public and same using for personal gain. 87 numbers of FIR at present.
My lord, page 8, kindly see the FIR, Lordship. What is the allegation in the FIR? Kindly see, Lordship. Allegation is, Lordship, against me, other Lordship, with due respect, married Lordship, at page 8, Lordship. Lordship got it.
Hmm?
Page 8, Lordship.
Vernacular 11, page 11.
Yes, vernacular, it may be written. Vernacular is, my lord, kindly see vernacular.
Yes. Great.
My lord,
Great.
my lord, translation or vernacular? Translation, I'm reading from translation, Lordship. With due respect, I state that the aforementioned accused persons are residents of Dhupguri Pathar village under your jurisdiction and operate a self-help group named JEM. The accused persons opened a self-help group SHG named JEM. The accused persons opened a main office in the village and collected lakhs of rupees from the simple and innocent people of the locality under the guise of the savings for the group. The second and third accused against the allegation, Lordship. Second and third. The second and third accused persons claimed that they were involved in government and private contract work both inside and outside Assam on the pretext of the group's savings and investment. The accused persons took a total of rupees 6,22,000 in cash from me, Lordship. How, my lord, huge amount, my lord, he deposited, Lordship. Where is the source, Lordship?
He is the only
This is kind of false allegation because, my lord, some, my lord, they dispute in the self-help group, Lordship. Nowadays, in village self-help groups are there, Lordship, investments are there, there may be dispute, Lordship, private disputes, Lordship. FIR, thousands of FIR may be lost, Lordship.
My lord,
Such a what I'm submitting, such a situation, such a case, whether my lord further custodial integration is necessary, Lordship.
required, my lord.
Documents, my lord, self-help group documents is also already there, Lordship. Police has seized, Lordship. Now documentary evidence, Lordship, 60 days offense, my lord.
My lord, short date may
During
be
this
given.
10 days, my lord,
I'll put it the
what will
there,
be
my
the
lord.
purpose for further detention, Lordship?
Short date may be given, my lord. I'll put it
49
the
days,
case there.
Lordship.
You have not received
Any
it.
condition may be.
My lord,
Is there?
not received, not received.
What?
Yes, they not received, my lord.
But your report, you have submitted the report. From
My lord,
the-
only report came here, my
My
lord.
lord, intention is
Yes,
to
ma'am.
keep me in jail, Lordship. No other purpose is there, Lordship.
No, my earlier CD was called for on 11 to my lord. Then one my lord, information jail authority was also directed to what is the it was perhaps it was came from the jail authority, my lord.
My lord, this is the interim order
Report,
to
my
the, my lord, other accused, named accused,
The
Lordship.
report came from the
Who
my lord, jail
persons have been
authority.
granted interim
The
bail,
report
Lordship?
came from the jail authority, my lord. It was directed by the lordship, my lord, regarding his health.
Why
condition.
CD is not?
Or CD is not, but not any information.
That is why, Lordship, I am, if my lord, your Lordship not, my lord, grant final bail, or maybe I may be directed to be released on interim, Lordship. Any condition may be imposed, Lordship.
CD was not called for.
CD called for on 11 to.
In the antecedent bail also, my CD was called for, Lordship. Another application, this is, my lord, two persons have been granted interim bail, Lordship. They are outside, Lordship, I am inside. Even then, investigation is going on, Lordship. My lord,
Lordship may fix on 26 or 27, my lord.
26 almost, my lord, it will be, my lord. Today is 20. So for 55 days, my lord, what will be the purpose for keeping him in jail, lordship? Already interrogated, police remand was, my lord, judicial, sorry, police custody was there. May, my lord, kindly be considered, lordship, that this aspect. Length of detention, my lord, may be taken into consideration, lordship. My lord, the other two accused are on, my lord, pre-arrest bail. Even then, my lord, investigation is going on, lordship. Any condition may be imposed. I will go, my lord, day by day, lordship, before the IU, lordship, if necessary, lordship. Kindly be considered, lordship, my lord. His health condition is not good, lordship. Even if it is, my lord, serious, not serious, my lord. But my lord, as per instruction, 4 days he was taken to civil hospital, lordship.
He is good. At present, he is good.
He is good. Report is there.
Everything is normal.
But some problem is their impression, lordship.
I don't know.
Anyway, lordship, length of detention, overall, all aspect may be considered, lordship. Length of detention may also.
Sit from jail provided the medical for this submitted by Mr. Amit, presented. Is he, as per you, who he works in department?
My lord, he is contractor, my lord. License, contract license is there, lordship. Annexer, S15, lordship.
Is not ethics with the elite office. There are only election of creation of a self expectation is creating a self no, there is any misappropriation was not be misappropriated any money from Mr. Ahmed submitted created problem. And on 4 occasions he had to be taken to hospital for treatment. Ahmed also furnished one medical report from which is collected from the log hospital. Civil hospital, Nogam hospital. Mr. Ahmed further submitted that accused in custody since last 49 days, and hence considering his lack of detention, he may be released. Further submitted that the that most of the co-accused are already released on bail, and still they are cooperating in the investigation. Apart from that, the police present accused petitioner was also under police remand for 4 days, and hence the IU got sufficient opportunity to interrogate the present accused, keeping him in custody. Accordingly, he submitted that petitioner may be allowed to go on bail. However, he is ready and willing to extend his further cooperation in the investigation of this case. Next paragraph, Mr. Dat Sharma, the learned edition PP's PP raised objection, submitted that it is to extend the privilege of bail at state without prejudice of the case direct, as from the recording report itself, it is seen that there are about 87 numbers of FIRs pending against the present petition, as he had misappropriated money for several persons in the name of giving some loan and gratuity except loan and in for loan through self-help. Mr. Sharma further submitted that as per medical report submitted by the jail authority also, it is seen that his health condition is good at present, though he was taken to hospital by the by the jail authority. Next, during the submission made by me also, it is seen that there is a allegation of the misappropriation of quantity of money, huge quantity of money, but there is no such clarification as to the said amount, except only amount of rupees 6 lakhs 20. Apart from them, it is seen that the accused was also under police custody for 3-4 days, and hence the IO got the opportunity to interrogate him, keeping him in custody. And since then, the accused petitioner is in custody for last 10 years. So without going further detail into the merit of the case, only considering the length undergone by the accused petitioner, I find that to the interrogation may not be necessary for the purpose. The case is pending before which court?
My lord,
Hing,
not
Naga.
just. My lord, alert CGM lordship.
Naga. The jurisdiction of CGM. What is AB then?
Your Lordship, item number 46.
Oblige us.
Yes. AB now, see AB though we don't have any CD.
Your Lordship,
Are
the
you on
matter,
interim?
yes, Your Lordship. The matter was last listed on 17th of February.
Yes.
And the diary was called on 6th of March, Your Lordship. And interim was continued as per
Interim
6th of March.
6th of March, Your Lordship.
Then to be listed again on 6th of March.
6th of March. Interim may be continued, Your.
Why it is listed today?
Due to some technical fault, Your Lordship.
City not received. However, the record indicates that the present case was listed on 6/3/2025 for case died. Later matter be accordingly listed on 6/3/2026 for city. Traditional people will call for the same. Interim be continued till next day.
Deeply obliged, Your Lordship.
Martha. इसी को दिया फल की बहुत जगह साफ था
May I please, your lord? My lord, in this case, my lord,
Yes,
the
you are
branch
13.
manager,
You are on 13, na?
13 million.
Yes.
My lord, the branch manager, State Bank of India, Dibrugarh branch, my lord, has filed this criminal revision petition, my lord, against the criminal proceeding, my lord, by complaint case number 89 of 2025, initiated by the, my lord, respondent number 2 here, Manju Saikia, my lord. Your lordship will find as the cause title. Respondent number 2, Manju Saikia. Respondent number 3 is her son, my lord, Babul Saikia. Now, what has happened, my lord? The predecessor of this, my lord, respondent, that is the husband of Manju Saikia and father of my lord Babul Saikia, had a plot of land measuring 1 katta 10 lecha. My lord, after his death, the land was partitioned in between the legal heirs, my lord, the Babul Saikia as well as, my lord, the Manju Saikia. Now, Babul Saikia, my lord, by way of purchase, my lord, sale deed, he purchased the land of 15 lecha from his father. Therefore, there is no, my lord, dispute over the, my lord, the properties that has been left by the father. Now, my lord, this Babul Saikia, my lord, on the basis of his title, he, my lord, approached bank to us, my lord, for, my lord, extending loan on the basis of house loan, my lord, on, my lord, by mortgaging, by creating mortgage of his title deed, my lord. Bank on verification, my lord,
extended loan. Now, my lord, the Babul Saikia, my lord, he defaulted in payment of, my lord, the installment. Accordingly, it was, my lord, the account become NPA. Bank accordingly initiated, my lord, SARFAESI proceeding as prescribed under the law, my lord, your lordship aware, my lord. When they have, my lord, the bank, my lord, issued notice for taking over possession of the property which was mortgaged to the bank. My lord, this complaint petition has been filed as a counter blast, my lord, against the SARFAESI proceeding with an intent to stall the SARFAESI proceeding. My lord, this is absolutely, my lord, abuse of the process of law. My lord, there
Where
is
the
no,
FIR?
there is
What
no,
allegation they brought in the FIR?
my lord,
What kind of allegation they brought in the FIR?
allegation, my lord, in the complaint that, my lord, he has, by forging signature of his father, Babul Soikia, has obtained the sale deed by way of, my lord, by playing fraud. That is the allegation against Babul Soikia. There is no allegation against the bank, my lord. However, the bank has been, my lord, made accused number 2 in the proceeding, my lord. And accordingly, my lord, we have filed this application. Thereafter, my lord, the learned judicial magistrate, my lord, with all respect, my lord, erroneously, my lord, without considering the facts of the, my lord, case in its proper perspective, my lord, issued process against the, my lord, bank branch manager, my lord. At page, my lord, your lordship will find page 18, annexure 2. This is the process, my lord, issued to us, whereby we are directed, my lord. Unnecessarily, my lord, this is the quarrel in between the mother and son, but unnecessarily we have been dragged into the court. Now, if your lordship pleases to see the allegation that has been, my lord, leveled in the complaint, my lord, your lordship will find that we are the victim. Even he has played fraud upon the, my lord, by taking sale deed, fraudulently purchased. My lord, that is, my lord, in that case also, my lord, in that transaction, my lord, bank is the victim. Where is the question of the
But
criminal?
you did not make any inquiry regarding the genuineness of the document and all.
My lord, we found
now you are
genuine.
saying that it is a fraud document was fraudulent.
We are not saying, my lord, it is her case.
No.
She filed,
At the time of granting or sanctioning loan,
my lord,
you
my
have
lord,
not inquired the matter.
we, my lord, inquired. We
is the
inquired
issue.
generally, my
That is
lord,
the
bank,
connivance with the branch
as a
manager.
bank, what
the
we
case.
see, the title deed, my lord, and whether it is free from all encumbrances. NEC certificate, patta, jamabandi, land revenue receipt, and thereafter, my lord, there is an, my lord, expert who gives the opinion. On the basis of the opinion, we extend loan.
Suppose if any government employee seeks a loan before any branch office or maybe SBI or any other branch,
My lord.
generally they make an inquiry in every aspect. They even visit to the office whether the person is genuinely working there or not, what kind of document, and but you are giving while a private person.
That we have inquired into, my lord.
Inquiry.
We have made inquiry.
That's why these are the cases. That's why.
My lord, we have inquired, we have filed, everything is reasoned valid, my lord. That is why, my lord. But the allegation, my lord, there is no iota of evidence, allegation against the bank for, my lord, criminality. Therefore, my lord, I pray for suspension of the impugned, my lord, process, my lord, against the bank.
58 BNSS corresponding to section 420, 480 for quashing of the complaint and all subsequent proceeding in the complaint case number 89 of the 2025, CR 89 of the 2020, pending before Court of Learned GMFC Dibrugarh Assam. Dibrugarh Assam issue notice to the respondents through speed post and usual process. No comment. This is required to be served and the state Support of its activities. Further considering this submission made by Mr. Said regarding constitution. Further proceeding in respect of the present petitioner be stayed till next date of listing. Further proceeding in CR case number 89 of 2025 be stayed in respect of the present petitioner till next date.
Pending before JMFC Dibrugarh, madam.
Pending before JMFC Dibrugarh. We'll write till next date of listing. List accordingly. You just take step, we are listing, staying it up.
Your lordship has
proceeding is the state.
stayed. Because we have no objection, my lord, if the proceeding, my lord, goes against the Babul Saikia sir, my lord. We have no objection. Let there be, my lord, let the proceeding goes on against them.
In respect of you only, we have stayed.
My, I am deeply obliged.
Number 20. 20.
Here CD not received, my lord.
They are on interim or no?
Interim, my lord.
Interim is, this case is pending. It is of AB 344.
My lord, interim was granted on 10-1.
Yes. Thereafter, why it is been listed? Listing? Not listed. And the case is of 2024.
Case is 2024.
There. When I was there,
yesterday also that type of case was there. Like I filed there yesterday, my lord.
It was extension. Sometime maybe extended for appearance of first query. After two mistake. Sweet. Non appearance of is submitted by Mr. Sharma that CD also not received. Issue reminder the police station as the cases seems to be as the case is pending since 2020. I is hereby directed to punish this CD on or before the next date without any testing matter according where it can be.
My lord, sort that, my lord, it may be 6 March, man. 6. We will verify.
A bit long, it you can give 13, 14 March.
My lord. Then, my lord, 17th March.
Interim be continued. For to dispose the CD.
24.
কি লিখিব
পয়সা আছে না কিন্তু নাই তার এতিয়া হৈছে objection আছে ন
Yes.
My lord, here we have received a case there, my lord. I have talked to IO also in the morning, my lord. She said that, my lord, the present petitioner appeared after interim, my lord. But his statement is not available in the case there, my lord. That's why I've talked to IO concerned, my lord. In the case there, his statement is not available. That's why.
But otherwise, as per your information,
He has appeared. Statement also recorded.
Yes, you are for the normal information. Yes, Mr. Hussain, what do you want to say?
My lord, allegation is
Which section?
abatement of suicide, my lord, husband and wife, my lord. Husband living in Vishwanath and wife living here in Gauhati, my lord, because both of them are service holder, my lord.
Committed suicide.
Thereafter, she committed suicide, my lord, and thereafter FIR was lodged against me by the mother-in-law of the petitioner, my lord. And thereafter, I grant interim protections. Initially, I appeared several times, and later on, 2/12, last year, my lord, my statement also recorded, and my learned friend has already said that I have appeared, my lord.
2/12.
2/12, my lord, I have In earlier occasion, although I appeared, my statement was not recorded because I was not available. And 212, I was available, my lord, and my statement also recorded, my lord. And in this regard, earlier when my statement was not recorded, I have filed an
And
additional
for the
affidavit.
case, there it also reveals that FSL report also received, my lord, and it was sent for, my lord, final PM report. It is also sent for.
So I
Any poison was there as per FSL?
My lord, FSL, my lord. No poison. No poison was detected.
It was a case of suicidal hanging or
Hanging. Suicidal hanging. In the PM report, it was not antemortem suicidal hanging.
I am cooperating with the investigation, my lord.
But if lordship goes to the merit of the case, my lord, details are there, my lord, against him also, my lord. Witnesses said that, my lord, he was mental torture was there against him also, my lord. And he also wants to court marriage, but thereafter he give the assurance to for social marriage, but he did not do so, my lord. Thereafter she also that also there, my lord.
social marriage was not taken.
That why দুইজনে কোৰ্ট মেৰেজ কৰিছিল যদিও সামাজিক ৰীতি নিয়মৰ মাজেদি বিয়া নকৰো বুলি অবিনাশে গংগুটিক কৈ আছিল, যাৰ কাৰণে গংগুটি মানসিক অশান্তিত ভুগি চিপ লৈ আত্মহত্যা কৰে. That is also there against him also.
But prior to her commitment of the suicide, was there any statement in regards to abetting her or abatement, or for which she was bound to take such steps? Is there any?
That part is not, but both of
She
them,
mentally may go depressed.
both of them husband and wife, my lord. Both of them husband and wife, my lord. They are
Both are living separated because of their jobs, my lord. I was now working at Vishwanath, and she was working prior to her death, my lord, at Gauhati. So our court marriage has already been, my lord, executed, my lord. And for social marriage, we mutually agreed in a later date because of our professions and my lord. That's why. In between, my lord.
death of incident, my lord. Hey. On the death of incident, my lord, the husband also called one of the friend of the my lord, wife, my lord. That statement are also there, my lord.
Yeah. Yes, what do you want to say?
We are filing an opposition.
Affidavit.
Objection.
Today.
No,
It is with the record.
I have received on 25/12, my lord. They are affidavit in opposition.
Let me see. I said
We filed a pen drive, your lordship, where all the people record in there. Filed pen drive, your lordship. For the investigation of the petitioner, the victim committed suicide. Mental torture, telephonic conversation, your lordship. Yeah.
So have you produced those, the pen drive and the other devices before the police station?
IO?
Before
Yes.
IO, you have submitted all this? So better to submit because IO it will be.
Then the IO will
the
take
IO
5 million.
because how far it is authenticated or
Minor.
authenticity, we are in a not.
What is in the
position.
minor?
And if you have some, better to produce all this before the IO. It is very essential on your part also because it will help the IO also in
Minor.
conduct
For the
further investigation. And if such things are there, or on the day, that very day of incident, he was just asked her to commit suicide, or you for his insistment, if she committed the suicide, that it may not be a case for bail also. So you do one thing, produce all these things before the IO. That these we will call it for the case diary again with the statement of the petitioner also, because you have got some serious allegations. So that has to be said. Okay, then hard given number hard Mr. M.A. the done it petition. Also hard Mr. B. Sharma, the learned additional BP appearing on and Mr. You are Mr. R. Ali appearing on behalf of informant, informant. Stop. It is submitted by Mr. Sharma that CD received, but the statement of the present petitioner is not available in the case diary. Though on telephonic conversation, it is informed by the IO that the accused petitioner appeared before the investigating officer and his statement is already recorded. Mr. Hussain, the learned counsel for the petitioner, also submitted that the accused petitioner earlier appeared before the IO, but his statement was recorded on 2/12/2025. He further submitted it is an admitted fact that both the petitioner and the deceased got their marriage registered through special marriage, but there was no social marriage till then with their mutual understanding. At the time of incident, he was discharging his duty at Biswanath Charkeli, and the informant victim was discharging her duty in Gauhati. In that context, Mr. Sharma, the learned submitted that though the statement of the petitioner is not available in the case record, but there are some other witnesses who brought the incriminating materials against the present petition. At the same time, it is submitted by Mr. Ali, the learned counsel appearing for the informant, that on the day of incident, there was a quarrel and and over telephone, he insisted her to commit suicide. Everything has been recorded, and they also produced one pen drive before this court through their objection. But on inquiry, it is submitted by Mr. Ali that they have not submitted any such pen drive or other materials before the IO during the investigation. In view of this, the informant is hereby asked that he is at liberty to approach the police station with some evidences, as well as he is also at liberty to produce the pen drive before the IO if it is required for the purpose of investigation. In view of this, let the CD be returned, calling for an updated one, including updated one, and the accused and the IO is also hereby asked to annex the statement of the petitioner if already recorded, and in the same time already recorded. In view of this, let the CDB press updated case diary be called for. Fine. You talk to the registry. কৈছা আপোনালোকে নিদিলে মই কৰি দিম আৰু when it can be
My lord, that is মানে 2020 March 2020 March
20
20 তারিখ
updated case study for interim may continue till next time.
Fine.
Yeah.
20th month.
You talk to registry, otherwise I have reflected here in the order. So you just talk to the registry. If it is, if it can be permitted, then yeah.
Yes, no, please.
26.
My lord, an anticipatory bail petition, my lord. And earlier occasion, my lord, CD is here, my lord, and the election is to. Yes, sir.
So we order was there for retaining.
We have scheduled.
And today's another matter is there in item 30, my lord. So I have inputted those mentioned in 30, my lord, same from same FIR, my lord.
Yeah.
Both-
30 mention করছি।
Mention 30 is same
30.
related.
30.
30 is also related with this case, my lord.
Mention করেছি।
Same FIR, my lord, 3 accused.
Mention করছে না? Mention করছে না?
30 morning. it
Oh,
was
mention.
Mention, but it was, they have also not said that it was related with that.
Oh, they have not said it. Lord.
That CD not here. That's why that's a
simple. Yeah, we
Mistakenly it was happened.
we did whatever in the morning hours. It was
but in the order, it was that CD not.
what to do there? We are not at that period of time. How can we say?
That's it.
My lord,
We are also not aware of that.
That water connect.
mistakenly happened, my lord.
We were not aware of, in fact. The simple submission that she did not receive.
Right.
So we thought that okay then. But it is
But,
for the same accused or
There are 3 accused, my lord. And in the other case, there are 2 accused, my lord. And here 1. And that 2 accused has
Here-
already been granted
here
interim protection
Islam
also.
is one.
Yes, my lord. And they are Shahjahan Ali and Shahidul Rahman Mondal, my lord. In the other case, are here Hashinur Islam is one. These 3 accused, my lord.
It's up to you now. You want to make submission here or you want to make it submission together with the other?
Here, my lord, in those 2 cases, my lord, interim was granted to them, but here I was not in interim, my lord.
Now, okay, at this stage, I cannot give you any interim.
And my lord,
You can submission. We
may I move, my lord? So, my lord, kindly have a look at the FIR, my lord. FIR is at page number. From 14 it is started, my lord. And the 11 portion. And 20 is the main FIR, my lord. Page number 20, my lord. Initially, it was sent to Director General of Police, my lord. Thereafter, it was referred to the local police station, my lord. May I read, my lord, 20?
Yes.
Subject district complaint against 3 reporters for alleged illegal money collection and
These 3 are they all are in the news.
yes, my lord. All are news reporter, my lord.
Better come together, I think. Afterwards, there may be some differences in the also. Can we inform Mr. who was there? Mr. Das was there. Can it be a shorter date in that case?
CD is available. Then again, then lordship, we may retain the CD.
No, that was on 13/3.
Or
It will be
no,
long
we
for
have to
you.
prepone.
Will it be long for you because you are not?
We will prepone then, lordship. I will inform them. I will inform Surojit lordship and let the matter be fixed on any date, lordship. I will inform to him. Key date.
Next week. Next week.
No.
Do it two on 2.
Very low.
Second of March can be.
I am not in interim, my lord. May protect me for other accused also under interim protection, my lord.
We can.
The same litigation is there, my lord, against.
Second March. 2nd March.
And prior to that, if possible, my lord. Today is 20, my lord.
Next week is not at all possible. 25th, also many matters have been fixed. 23rd,
Lordship, that is why
with the cases
Yes,
24
if
one
your
part
lordship,
that is
it
there.
is the interim protection may be
Lordship, that
given,
is
my
why-
lord.
Came from till 1 only, we are sitting on 24, 25, many matters, 26 and 20 similar wise. So that's why we're giving on 2nd of March.
If your lordship, please, my lord, the interim,
No,
my lord.
sorry, 2nd of March. CDP written till next date.
I will inform Lordship.
Will
I will
someone
inform.
who's recorded will try to prepone it.
I will inform you.
Okay. We do prepone. They have taken care of
My lord, then this matter will be take up with the death matter, then it will be come up with together, my lord. Otherwise, again,
Okay, then now.
that is WPC one, AB 171 2026.
Along with
171, AB 171 26. Item 30, my lord.
171, AP 171, 2026.
26.
Okay, realistic.
Yeah.
Very good.
About equity.
27, 28, 30.
I will inform. Bokut. Second mark. No.
So any date, my lord, your lordship may please the my lord. Yes.
Here report was called for, my lord. My lord, my lord. That report also received, my lord. Received, my lord.
Yes, yes, ma'am. Yes. Since he is not, my lord, there, ma'am. Appearing counsel is not there.
Yes, my lord. Sorted, my lord. Monday of it. Oh. 25. 24.
Lost. My lord, interim to continue, ma'am. There is in interim order, ma'am. Lost.
Met your lordship, my lord. Both the case out of same FIR, my lord. 27 is AB. Your lordship kindly take up 28 first, my lord. Item 28. Today, 82 days, my lord. 302. Now, whole case is, my lord, that father-in-law and son-in-law, all family members, my lord. You will kindly see the FIR in page 28. Your lordship kindly see. Item 28.
Page 10.
Page 10. Page 10. Item number 28, my lord. Page 10. Your lordship will find the most respectfully state that today on 29, 11/25, at about 1 p.m., me and my brother Alamgir went to, me means my lord, that the informant,
me and my mother Alamgir went to so-and-so hotel to have a food. At that time, on the ill advice of accused number 3, the accused number 1 and 2 started fighting with us on the pretext of idea. Some dispute was there on the idea. Then I informed my father over phone about the incident. When my father informed the matter to the accused Akbar Ali over phone, then Akbar Ali, in order to discuss, some wrong translation is there, madam. In order to discuss and compromise the matter, call in the house of that accused persons. We and our father, along with 6 other persons, as soon as we went to house of the accused person at so-and-so, then accused number 1 and 3. 1 and 3, my lord, that is not the present petitioners.
One is
Sorry.
one is here.
1 is there, madam.
Three
Yes,
is not
Mahalam. Yes, 3 is not there. So 1 and 3 started assaulting my father. The accused number 5 brought one iron shovel and handed over to the accused number 6. And then the accused number 6 hit in the neck of my father, for which my father fell down, and immediately for the treatment we took to so-and-so, but doctor declared him dead. Now kindly see the, my lord, the name of the deceased, my lord. Mahalam Ali, son of my lord, father and son, before lost with my lord. Yes,
Usman Ali.
Usman Ali died. Usman Ali is
Brother-in-law.
the brother-in-law of petition number 2. Own brother-in-law petition number 2, my lord. Petition number 2 is Mahalam Ali, that is Hameda, son of Hamed Ali. Hamed Ali is, my lord, he is the informant's own maternal uncle, Hamed Ali. Your lordship, that is petition number 1. Accused number 6. Accused number 6 is own maternal uncle of the informant. And informant's father died. And Akbar Ali is the, my lord, he is the, yes. Joseph is also, Akbar Ali is, my lord, is the grandfather, maternal grandfather of the informant. So all are, my lord, son-in-law members. Only, anyway, my lord, 82 days, my lord, all the family members matter, though it is not, should not be said, but already settled, they are now living peacefully, my lord. Further custody, so far, this particular concern, I'm all on that, my lord, at this stage. I'm on a length of detention. Yes, father and son, my lord. And father of own son-in-law died. So in cross case is also there. Your lordship can find cross case. Yes. So, case number 6, wife has this file the cross case, my lord. Cross case, your lordship will find page 18, 1-8. Wife of Hamed Ali, my lord. That is present petition number 1. Yeah, present petition number 2. Yes, 2's wife. So same manner, ultimately, son-in-law, father-in-law, mother-in-law, my lord, it is there. I am not at this stage, my lord. Maybe I do not know the medical, but anyway, something happened, a person unfortunately died, my lord. My own, my lord, relation, my lord. Own relation, in-laws relation. So I only, my lord, I share so far this petition of 28, item 20 is concerned. Only kindly consider length of detention, my lord. 2 days will go if you get certificate, if your lordship allows, my lord. Oh, that way, my lord, I pray, my lord, on the basis of keeping in view of the relation of the parties, my lord.
My lord, here we have received the case there also, my lord. Well, this is in there, my lord.
Yes, I am not on merit at this. So this part,
and maybe PM report also supported the, my lord.
That I am not disputing your part. Only, my lord, further custody 8 days, nobody will be prejudiced by keeping them 8 days, man. And there is no chance of, yeah, my lord, because some other persons also have not yet been taken to custody, so it will take time, my lord. Only 2 persons were arrested. 1 person before lordship, so AB is concerned. Rest have not come. So ultimately, charge sheet will not be there, my lord. So I think, my lord, for the ends of justice, I leave your lordship, my lord, your lordship kindly consider that part. I'm not on merit at this stage.
from the materials, although
No, that
it is
I-
said
I-
that
I'm
my
not
only
disputing.
length of detention, but my objection is there, my lord.
Yes.
As in all the cases, my length of detention is not the consideration.
Well, that
Here it is the my lord 302, my lord 103, my lord here. But see, all the witnesses, eyewitnesses are there, my lord. Media, PME could also supported, my
No,
lord. My
you are right.
objection is
I'm
there,
not
my lord.
disputing. You are right.
All the cases, length of detention is not consideration. This is a case of rejection.
Yes.
Still under investigation.
There is no chance of charge, but the other persons have not before worship. Only one person, item 27, AB. And he is 65 years old, man, AB, so, and Abdul Latif কি করবো? লাভ ভাই তোমাকে ভাই কথা তোমাকে ছেড়ে লাভ আপনি আমাদের জমিতে নাম ফান্না লাগে ভালো না বেশি হয়ে গেছে কি করবো What is this one? What do you put my? CGM goal for.
In a short period also will be possible. Considering this aspect, considering this aspect of the case, and without going details in merit of the case, only considering the length of detention already undergone in investigations. This court is of opinion that bail can be granted. We will bear at the court privilege of bail in view of distance. It is a case of which district?
Golpar, it was CGM Golpar.
Satisfaction, CGM. Yes, what about the AP?
That is matter as his role subject to my hotline. I do not find his role is only education is that he has given handed over the one instrument to accused number 6.
Oh, he to handed over to Sabulai.
Minor, minor.
And he is the actually he is the maternal grandfather of the informant, own maternal grandfather. And he was not there.
He was there.
He is there, my lord. He has taken that to from his home, my lord.
Our instruction is
My lord, from his home, my lord.
my lord,
And
we
he
are not
gives the
disputing
others,
whatever they say, my lord. What instruction we got, my lord, we are saying.
But CD reveals
Anyway, my lord, that I leave to your worship, my lord. His age consideration, my lord, and his role, I do not know his role as anything.
Age is
How
not
old
the
he is?
minor.
He is
Only
actually
65 years.
here it is 65.
Only
but
65
Now,
years.
let's say only 65.
Only 65 years. Only 65 years.
As per Bhutan, 69 mile.
Anyway, if
Anyway, my lord, that is
65, so is not a headache. Yes, sir, anything to say.
My lord, but his that conspiracy part will come against him also, my lord.
Conspiracy, no, he is the person who.
Person, my lord, who has taken the sample, my lord.
my-
And he hand over to another thing, he assaulted my lord and died, my lord. My lord, my objection is there, my lord, in serious such type of serious offenses, my lord, all of them together involved, my lord. Only that he assaulted, he is not the only person, my lord. Others who help him, they all are responsible, my lord.
he
All are
the
responsible.
discharge was given to him. As per my lord, that year, he was that Akbar Ali, he was informed from the hotel. So these people are attacking, assaulting us. Then Akbar Ali came to their house.
And taken Sabul
No,
from
no,
his home.
he was called by that informant. FIR says, madam, FIR says. He was called by the informant. Your Lord kindly say FIR, what he says, madam. I informed my father, my lord, your Lord kindly say, I informed my father over phone about the incident. When my father informed the matter to accuse Akbar Ali, your Lord kindly know.
In which affair?
So this page 10, same FIR. Barnacular is also there, my lord. They are called him, my
What one?
as per
Discuss.
FIR. Subsequently, he was intimidated only matter for that purpose, given Shabal to him. But in fact, how he can conspire? Common interest.
All of them involved, my lord.
No, I'm not saying he was called by that EMI as per FIR itself.
Lordship, may kindly say, Lordship FIR is not the inconclusive, my lord.
No, I'm not saying
Is
it.
there, my
At
lord.
this stage, my FIR is
In the initial stage investigation, in my lord, FIR is lost only information regarding the my lord, non-billable offences, my lord. But after investigation, it is revealed what is happening in the my lord, in the incident, my lord.
but when my
Kindly
father.
read the statement, my lord. Eyewitness, they have said that, my lord. Akbar has given the sample to the my lord, person who has assaulted. That is there.
But the only question was whether I had intention. I was called by them, my. You all kindly see whether I was called by them. I have not gone to kill him, my. I have gone as per that, according to them, my, they called me.
My lord, if he has not the intention, my lord, why he will give the sample to the to
That
cause him
whole
death?
part it is whether it is correct or not, that to trial matter.
Where he will give the
But
sample
basically,
to cause
initiation is that I was called. Not I have on my own, I have come. So my involvement only can say from that my involvement, whether I had conspiracy, whether I had common intention, whether
That
common
will be the
assembly.
matter of trial, my lord, whether their intention is there or not. At present, prima facie material is there against him.
I lift your lordship, my lord. I think, my lord, nothing is attributed to him so far conspiracy part other things. He himself, he is saying, FIR itself says. I told my father, and my father called Akbar. And Akbar is the maternal grandfather of the informant, maternal grandfather of the informant. Nana. He rather nowadays he compromised the whole matter, my lord. Both parties are now living very happily and securely.
After date of a
Akbar Ali. He is the elder.
Compromise the matter, came to compromise the matter, but later on he gave the sample to cause death.
after date of the part one
Now they are my ultimately your in-laws matters. I'm not saying it happens. It happens. How it happens, I am not saying so. But it happens. Ultimately, happen. He will not come back, my lord. So what role, my lord, is there And he called them to compromise, my lord, to discuss and compromise them. This is itself says that it's FIR says, my lord. So how much conspiracy part comes, how common intention will come, my lord.
My lord, here I am reading from a vernacular, my lord, page 14, my lord.
Yes, sir, vernacular.
মই ফোন সেই সময়ত 3 নম্বৰ পদকীয়া কুবুদ্ধিমতে 1 আৰু 2 নম্বৰ পদকীয়া আগৰ কথালৈ আমাক মাৰপিট কৰে সেয়েহে মই মোৰ দেউতাক ফোন যোগে ঘটনাৰ বিষয়ে জনাও আৰু মোৰ দেউতাই পদকীয়া আকবৰ আলীক ফোন কৰি ঘটনাৰ বিষয়ে অৱগত কৰাত আকবৰ আলীয়ে ঘটনাটো আলোচনা মৰ্মে আপোচ কৰাই দিম বুলি কৈ পদকীয়া ঘৰত মাতে for the pretext of compromise, my lord, they have taken to the man. পদকীয়া ঘৰ মানে 21% taken to the accused person's house, my lord. সেয়েহে আমি দেউতা সহ 5জন মান মানুহ পদকীয়া ঘৰত যোৱাৰ লগে লগে 1 নম্বৰ আৰু 3 নম্বৰ পদকীয়া মোৰ দেউতা ওছমান আলীক মাৰপিট কৰা আৰম্ভ কৰে they have called them to the house of the accused person.
But one thing is there,
Well,
obviously, from the FI, it seems that he was informed initially by the informant that so and so. Then only he came to please come to our house.
Compromise and
He gave a compromise. And for compromise also, how many of them come? Not the father and son. The entire 4, 5, 6 persons came to the house of the. So there was a scuffle, and it seems overall. What had happened subsequently, definitely one person died. We can understand. But the overall situation, if you visualize the situation, they only son and father, they have not come. More or 5, 6 members, they have come to the house of this witch. Ultimately, that incident had happened. That is the case. Anyway, I heard Mr. H.R. Chaudhary did an senior Mr. And did an Mr. Bisham did an application section so and so in connection with so and so. It is submitted by Mr. Chaudhary that the present accused petitioner is not be connected with the LS. Rather, he was called by the accused, called by the informant side, and when he assured for the compromise of the. But when the informant along with some other persons traveled the house of the accused petitioner, some unfortunate incident. But this petitioner is no way involved in the case, nor he played any role in the conspiracy, in the said conspiracy to kill the deceased. The accused person is more than 65 years of age, and hence considering his age also, his prayer for pre-arrest bail may be. However, he is ready and willing to extend his cooperation in the further investigation of this case if he is provided with the privilege of pre-arrest bail. Mr. Sharma did an additional PP raised payment objection submitted his for pre-arrest bail, as he is the person who handed over one Sabul to the other accused, and through that with the help of that said sub, the other accused hit on the deceased, and out of which injury he died. Thus, this petitioner also played a vital role in the arrest offense, and accordingly he raised objection. Next, further hearing this submission with also considering the entire incident, that one opportunity may be given the present petitioner to appear before the IO and to cooperate in the further investigation of this case. Petitioner provided with okay, you'll be under interim protection. Let your
obliged to
statement be recorded. Well, we're listing it on 19.3.
19.3. Obliged to loss.
Wait, wait.
Yes, no, has come. He will come. Another.
Oh, acha.
Another.
May it please your lordship. My lord, some status report was called for.
My lord, here not receive any information, my lord. Whether any FIR registered or not.
My lord, may I pray one thing, lordship? Lordship, I will be paying for some interim protection. Lordship, the land which is in possession for dispute, lordship, to respect of that land, lordship, already civil court has granted an interim injunction in favor of the petitioner, my lord. And the allegation which the informant has made before the SP, that too through post office, my lord, that complaint has been forwarded before the police station. And police is running after me, my lord. Even day before yesterday, police visited my home. My lord, the order passed by the civil court may be perused by this honorable court in respect of the same land. So, my lord, my limited prayer is that, lordship, till the information obtained by the PP, lordship, till the next date, lordship, no coercive action may be taken against the petitioner with relating to the dispute of the land, lordship, nothing else. Lordship, one order passed by the learned civil court at Dhubri. This title suit was filed by the petitioner, lordship, for temporary injunction. Miss case was also there. Lordship, the plot of land was 1 kata 5 lasha. That was bought by the petitioner in the year 2019, which the petitioner subsequently sold to the present informant, lordship, in the year 2023. That is the allegation in the complaint, lordship. And lordship, the civil court has granted.
Received the complaint.
Lordship, complaint copy I have annexed, lordship, but a complaint copy, lordship, at page 9, lordship. This complaint was sent through post office, my lord, by the informant to the SP. And the entire issue is of civil nature, my lord. They are giving a criminal color. And the allegation is in respect to some transaction for selling a land which took place in the year 2023 in the month of April, my lord.
He annexed one complaint subject of FIR, but that has not been registered yet, na?
My lord,
One copy of FIR is annexed as an annexure 1 in page 9.
My lord, page 9, my lord.
So that is one of the
FIR.
FIR.
Yeah,
I don't know whether it has.
My lord, whether it is registered or not, my lord.
That information was called for actually on the previous date.
My lord, Monday, my lord. Monday, I will pull it report, my lord. Today not received, my lord.
Monday. Many matters are already there. Anyway, you are Mr.
R. Karim, my lord.
R. Karim. Which number here? Mr. R. Karim. It is submitted to Mr. Sharma that they report the investigation. His house. The one complaint which has been sent through
Content of the matter to you.
And there is every probability of registering a case against it. However, subsidiary and the dispute is based on and the dispute is of land dispute, where the petitioner has earlier lodged an suit nominated Ms. Swearing. The injunction was also granted in favor of the petition. Mr. Karim accordingly submitted until they received the stay some interim protection considering the submission. The dispute Fakiraganj?
Fakirganj. Fakirganj, my lord.
Fakirganj. No, police station. Fakirganj PS, thereby directed not to take any coercive action till receipt. This demand accordingly when it can
Monday.
Some interim protection.
Right. Then some later on, my lord. 18th, my lord. 18th.
18th. List on 18th. Okay.
Lordship, can it be on 15th if it's
Then
possible?
this, then
Oblige, your lordship.
P6.
What is the
Ma-
position of 36?
Herein also your lordship instruction,
here also not received any report, my lord. As well, government.
but in my case also, your lordship, in some occasion, I have mentioned in my petition, para 5 of my petition, your lordship, the
Okay, we'll list it Monday or Tuesday.
Monday.
Is report not received. Issue reminder, the relevant additional people take necessary steps in obtaining the report from the concerned police station. List 20, 24, 20. Monday may not be possible, 24. Next day, Tuesday.
Wait, please, your lordship.
20.
City was there, but lordship has called
By
for
what time?
updated medical report. Anyway,
This is the
this,
city,
You
lordship.
can't do.
City we have received, postmortem is also received. After PCR test and final opinion. As per that, lordship, that anti-mortem drawing is there.
Drowning.
Anti-mortem drawing. And after going to the city, except one or two ionos, I have not found any direct implications of this person. Only Perus.
petitioner is not the owner of the fishery, your lordship. It's only a villager, your lordship. He's only a villager, your lordship, and he has no any complicity with this victim, your lordship.
The fellow was working in your fishery.
No. Fishery is owned by one Saurabh, that's accused number 1, your lordship. He is the owner of the fishery. So on the particular day, what happened, your lordship, he was catching, the son of the informant was illegally catching fish from the fishery. So when the owner of the fishery, Saurabh Das, came to know about it, he went to the fishery. When seeing the owner, the son of the informant left the spot by leaving his gamusa there. Thereafter, the owner of the fishery took the gamusa and he went to the house of the informant saying that your son was illegally catching fish. This is the gamusa he left behind. And from next time, if I see him, then I will take action against him. I will lodge a FIR against him and all these things he has said, your lordship. At that time, while going to the house of the informant, your lordship, this petitioner, who is also a co-villager, he also accompanied him. He said that such and kindly accompany me. I will go and file a complaint with the father of the person. Thereafter,
He is not the owner of the fishery.
he is not the owner of the fishery. This is there in the FIR itself, your lordship. Thereafter, after 2 days, your lordship, his body was found.
In the said fishery? It's
No. In a river nearby, in drowning condition. Accused number 1 is the owner of the fishery, your lordship. FIR lordship will get page 9. And it is stated also by the informant himself.
What is your name?
Lordship, my name is Ranjit Das.
Ranjit.
When he went to give the gamusa to the informant, at that time, I accompanied him, your lordship. I am a co-villager. 25 years old, your lordship, the petitioner.
Part Mr. M. Passport, Dilani, Council Petition. Also, Mr. B.S. Dilani, Petition, PPA, State. State. Senate petition. Submitted by Mr. Passport. Prove it. Fact that he incorporated the owner of the fishery, that is the case number 1 for the house being formed. When the applicants handed over one Kamusa to the that effort he has moved very connected and dated as he visited the house to be informed. The police is searching for seeking as an and hence this presentation has been filed seeking pre-arrest. Next one, Mr. However, he is ready and willing to extend his cooperation in further investigation of this case if he is granted with the privilege of pre-arrest. Prime Minister Lawford Ilanit additional PP submitted in this regard that PM report will the date for date and cause of death is as received from the it is stated that the deceased died due to anti-mortem drowning. But it is submitted that such implementing measures available in the case diary so far against the presentation. Next, however, it is submitted that the case is still under investigation and accordingly raise objection in granting the privilege of bail to the presentation. Next, during the submission made by Planet Council of Proceedings. So is right that is that and the possibility made the arrest to be presented to be presented. Okay, you are granted with the privilege of pre-arrest bail. However, there will be some conditions about by all that. Everybody.
I'm deeply obliged.
For episode number 70.
May it pleases your lordship. Lordship, in this the petitioner is the accused in special POXO case 57 of 2020 pending before the Court of Additional Sessions cum Special Judge POXO at Borpeta. Now, after a trial, a petition was filed by the father of the petitioner before the trial court stating therein that the petitioner was born on 1/3/2003 and the petitioner was a student of class 8 of Basbari Balimari ME school. And in that regard, the concerned in charge headmaster of the school had issued a transfer certificate in the name of the petitioner. And that was also submitted along with the petition, wherein it was mentioned that date of birth of the petitioner is 1/3/2003. So at the time of the alleged occurrence of offense, the petitioner was 17 years, 3 months, 22 days. So after filing of this petition, the headmaster was summoned before the court and he deposed as CW1. He brought the relevant documents and thereafter another transfer certificate was filed before the court, issued by the headmaster Golapara Part 3 LP School. And therein it was a class 5 living certificate, transfer certificate. Therein also the date of birth was mentioned as 1/3/2003. The headmaster of that school was also sent notice and he also deposed before the court as CW2. Then however, by the impugn order, the petition was dismissed, and hence against that order, impugned order, this revision petition has been filed. Now the impugned order is at page number 45. Page 45. Accused Saddam Hussein is produced from jail custody through VC. Learned counsel for the accused person is also present by filing Hazira. Today the case is fixed for NOC. The order dated 3/9/2024, wherein it is reflected that learned counsel for the accused Saddam Hussein filed a copy of his school certificate of Golapara Part 3 LP School in the name of accused Saddam Ali and verbally submitted that the accused Saddam Hussein was born on 1/3/2003 and he studied in class 5 at Golapara 3 LP school, and in this connection he relied upon one transfer or living certificate issued by the said school, wherein the date of birth of Saddam Ali is mentioned as 1/3/2003. Learned counsel verbally submitted further the alleged incident of this case took place on 26/3/2020, and as such on the said date, the accused Saddam Hussein was 17 years, 3 months, 22 days, and therefore was a CICL. So a notice was issued to the headmaster of Golapara Part 3 LP School to appear before the court along with the relevant records. Accordingly, on 22/10/2024, the headmaster of Golapara Part 3, namely Mukhlesuddin Ahmed, was present and was duly examined as CW2, and the relevant documents were also exhibited. On perusal of the documents, it appears that in the admission register at serial number 10, the name of one Saddam Ali, son of Muhammad Abdul Mia, is mentioned, and in the school living or reading or transfer certificate issued by the head teacher of Golapara Part 3 LP School, the name is also mentioned as Saddam Ali, son of Muhammad Abdul Mia. CW2 has also stated that the said date of birth was recorded on the basis of the self-declaration given by the father of the said student. It appears that CW2 also stated that as per the admission register, the student, namely Saddam Ali, son of Abdul Mia, of village 6 number Basbari, got admitted at their school on 7/1/2013 in class 5. It reveals from the evidence of CW2 that his entire evidence rests on one Saddam Ali, son of Abdul Mia, and the documents including the admission register and the school certificate are also in the name of Saddam Ali. On perusal of the case record, it appears that the informant had lodged the Ezehar against one Saddam Hussein, son of Abdul Haq. In the evidence of the informant PW1 and the victim PW2 have also identified the accused as Saddam Hussein and not Saddam Ali. The IO and other witnesses of this case have also mentioned the name of the accused as Saddam Hussein. Moreover, in the examination of the accused under Section 313 CRPC, the accused put his signature under the name of Saddam Hussein and not Saddam Ali. The father's name of the accused was also appears to be not similar. The name of the father of the accused was mentioned in the charge sheet as well as the statement of the accused recorded under 313 CRPC as Abdul Haq, whereas the name of the father of the accused was mentioned in the documents submitted by CW2 as Abdul Mia. In view of the above, it reveals that the documents submitted by the learned counsel for one Saddam Ali, the evidence and documents of CW2 in the name of Saddam Ali, son of Abdul Mia, cannot be considered to be the relevant documents to establish that the documents are for the accused Saddam Hussein, and as such the prayer for declaring the accused Saddam Hussein, son of Abdul Haq, as a juvenile could not be considered on the basis of documents in the name of Saddam Ali, son of Abdul Mia. Hence, the prayer made by the learned counsel for declaring the accused Saddam Hussein, claiming his juvenility, stands rejected. Let the case be fixed for argument. Accused is remanded back to jail hazard till so-and-so, fixing so-and-so for argument. So this was the impugn order. Now, my lord, the submission is that in annexure number 7 series at page number 27, page number 27 reveals the order dated 28/6/2020 passed by the court. The court itself has recorded accused Saddam Hussein alias Saddam Ali. Then again, at page number 31, while rejecting the bail application of the petitioner, the court has recorded this is an application filed by petitioner Mubarak Hussain under section 439 CRBC praying for bail of accused Muhammad Saddam Hussein and alias Saddam Ali. So in the court record itself, both names are there. And only on the basis of difference in surname, the petition was dismissed without appreciating the whole evidence of CW1. There is no mention of CW1 in the impugned order itself. CW1 has not been mentioned. Kindly come to page number 43. That is the deposition of the CW1. This has not at all been discussed in the impugned order. Page number 43. I have appeared today before this court on receipt of notice from the court. Today I have brought along with me admission register of Basbari Balimari ME School for the year 1988 to 2016. As per the admission register, the student, namely Saddam Ali, son of Muhammad Abdul Mia, at village 6 number Basbari, PS Manikpur, got admitted at our school on 1/1/2016 at our school in class 8. His date of birth as per the admission register is 1/3/2003. At that time, I was not the headmaster of that school. The earlier headmaster, Iyad Ali, had recorded the date of birth of Saddam Ali. I do not know on what basis the date of birth of Saddam Ali was registered. The name of said student appears in serial number 37 of the admission register. At the time of admission of said student, Iyad Ali was the headmaster of our school. Subsequently, one living or transfer certificate dated 2/1/2017 was issued by the then headmaster Deepcharan Das, as per which the date of birth of the accused was recorded as 1/3/2003. I was informed by the parents of said accused student that the earlier certificate was lost and that was issued without the counter signature of BEEO. I verified the counterfoil of the said certificate, wherein I found that the counter signature of BEEO was not there. So I issued a living or transfer certificate of Saddam Ali for the second time with the counter signature of BEEO and recording his date of birth as 1/3/2003, as mentioned earlier. Exhibit C1, CW1 is the admission register. Exhibit C11 is the entry in serial number 37 pertaining to the said student, proved in original. C2 is the counterfoil of the certificate issued in the name of Saddam Ali, and C21 is signature of the then headmaster, Deepcharan Das, which I know. C3 is the counterfoil of the certificate issued in the name of Saddam Ali for the second time. Exhibit C31 is my signature. C4 is the school living or transfer certificate of Basbari Balimari ME School issued by me for the second time, and exhibit C41 is my signature. So this was not at all considered. CW1 has not at all been discussed in the impugned order. And CW2 evidence is also very to the point, and there is no contradiction with regard to the date of birth. At least the date of birth in both the documents and in both the depositions is the same. At page number 41, I'm reading from para 2. As per the admission register, the student, namely Saddam Ali, son of Abdul Mia of village 6, number Basbari, got admitted at our school on 7/1/2013 at our school in class 5. His date of birth as per admission register is 1/3/2003. The said date of birth was recorded on the basis of self-declaration given by the father of the said student. The name of said student appears in serial number 10 of the admission register. I have also brought the original copy of self-declaration given by Abdul Mia. At the time of admission of the said student of our school, I was the headmaster of the said school. So he was there at the time of admission. Exhibit C5 C5 stroke CW2 is the admission register. C51 is the relevant entry in serial number 10 pertaining to the said student. In the page number 14, C52 is my signature. C6 is the school living or transfer certificate issued in the name of Saddam Ali. Exhibit C61 is the counterfoil of the said certificate. Exhibit C62 is my signature in the said counterfoil. C7 is the self-declaration made by Abdul Mia, father of Saddam Ali. So this has not been taken into consideration while deciding the juvenility of the petitioner in the instant case. And I'm relying upon a judgment of the Honorable Supreme Court, that is 2012 9 SCC 750. I placed the copy of one, it is in the record. One,
It is in the record.
it is in the record. Ashwani Kumar Saxena, on the last date I submitted, versus State of MP.
Yes.
I'm relying upon para 14. At page number, internal page number 8. In Arnit Das versus State of Bihar, this court held that while dealing with the question of determination of the age of the accused for the purpose of finding out whether he is a juvenile or not, hyper-technical approach should not be adopted while appreciating the evidence adduced on behalf of the accused in support of the plea that he is a juvenile, and if two views are possible on the same evidence, the court should lean in favor of holding the accused to be juvenile in borderline cases. In Aditya's case, this court has taken the view that the date of production before the juvenile court was the date relevant in deciding whether the appellant, this is not required. And I am relying upon paragraph number 36. Para 36, age determination inquiry contemplated under the JJ Act and rules has nothing to do with an inquiry under other legislations like entry in service, retirement, promotion, etc. There may be situations where the entry made in the matriculation or equivalent certificates, date of birth certificate from the school first attended, and even the birth certificate given by a corporation or a municipal authority or a panchayat may not be correct, but quote, JJ board or a committee functioning under the JJ Act is not expected to conduct such a roving inquiry and to go behind those certificates to examine the correctness of those documents kept during the normal course of business. Only in cases where those documents or certificates are found to be fabricated or manipulated, the court, the JJ board, or the committee need to go for medical report for age determination. Here in this case, no such finding has been arrived at that these documents were fabricated and all, and no medical examination has also been called for. And lastly, upon paragraph number 45. Now, in this order, it has been mentioned that it was on the basis of the declaration given by the father, these dates were entered into the register, and also the evidence of CW1 and CW2 also reveals the same thing. Now, that is why I'm relying upon this paragraph. We are of the view that admission register in the school in which the candidate first attended is a relevant piece of evidence of the date of birth. The reasoning that the parents could have entered a wrong date of birth in the admission register, hence not a correct date of birth, is equal to thinking that parents would do so in anticipation that child would commit a crime in future, and in that situation, they could successfully raise a claim of juvenility. So it clearly says that if these documents are available before the court, then those documents should be not a hyper-technical approach has to be adopted in those cases while determining the juvenility. And if there are two views or possible views are there, then that view may be adopted, which would benefit the juvenile. Because ultimately this Juvenile Act is also a beneficial act legislated for the purpose of protecting the interest of the juvenile. And moreover, with regard to the allegations, my lord, the petitioner and the victim, they were in a romantic relationship. She was also juvenile, he is also juvenile. And that is why when he was arrested, this POCSO was also attracted in the instant case. And further to be noted is that she did not appear for her medical examination. The report has been filed by the MO with that regard. MO was not examined by the prosecution. Neither the IO who has filed the charge sheet against the petitioner has been examined. It is revealed from page number 32. Page number 32.
What stage you're saying for MO, examination of MO?
MO was not examined.
That what stage you're saying for examination of MO? While passing the order or where?
Order was passed.
Production?
Order was passed at page number 32.
Oh, yes. At the time of production, you are saying MO was not examined or where?
No, later on.
Later on means?
Learned Special PP has submitted that he is not willing to examine the MO as the victim has refused to undergo medical examination.
Which page?
At page number 32. Annexure 9. 1, 2. Fifth line. Order dated 1/9/2022. Page 32. Learned Special PP has submitted that he is not willing to examine the MO as the victim has refused to undergo medical examination during investigation, and the MO has accordingly submitted the report. Issue summons to the IO of the case, Learned Special PP shall take steps. And just on the next page, at page number 33, the down below, order dated 4/11/2022, accused Saddam is absent with steps. He is represented by his counsel for the day. IO is present. He is examined, cross-examined and discharged. Prosecution declines to examine the IO who submitted the charge sheet against the accused.
Yes, now case is already disposed of.
Not disposed of, at the stage of argument.
Argument. So you are saying that MO and IO.
IO. So my prayer before the Honorable Court is that this petition be allowed and he may be considered as juvenile on the date of alleged occurrence, that is on 23/2/2026. As on that date, he was of the age 18 years, 3 months and 22 days. And this has been revealed from these two documents at page number 39, that is the class 8 living certificate and class 5 living certificate at page 40, and also disclosed by the deposition of the CW1 and the CW2, who are the respective headmasters of the two schools who have issued these two certificates. They have been proved in the original also.
Lordship, here in this case, Lordship, Lordship will file first say, Lordship, that who has committed the offense from the Azahar to 313 statement. From Azahar, Sarsit, thereafter PW, thereafter 330 statement. All along his name is Saddam Hussein. And subsequently, and his father's name is also Abdul Haq. And after 313, Lordship, this point raised that he is not Abdul Hussein. He is not Saddam Hussein. He is Saddam Ali. His father is Saddam Abdul Mia. So prior to that, everything was Saddam Hussein, or it goes continuous Saddam Hussein. So why if there is any such kind of anything was there, they would have to take the plea in the year 2020 itself, not in the year 2024. So Lordship, and even though if they have taken the plea, they can take the plea at the stage of appeal also. If there is any correctness, if there is any valid reason to believe. But what they have stated and what the court witnesses stated, Lordship, that initially where he was, where he entered his name, and subsequently in transfer certificate, in everywhere it is Abdul Saddam Ali and Abdul Mia. Then how we can add both the person, that Saddam Ali and Saddam Hussein is the same person, Abdul Mia, Abdul Haq is the same person. How it can be, Lordship? So that is why, Lordship, what the Supreme Honorable Apex Court decision that when two views are there, no, there is no any two views, Lordship. If there is any probability of two views that he may be this person, he may be this person, no. This is completely separate thing, Lordship, that there is no any two views. So that Apex Court or judgment will not come with this case, Lordship. Because there is no any two views that this person is this person. In earlier, if anything, if he was being addressed, he was being witnessed in anywhere, if they admit right or something that he is Abdul, this is Saddam Hussein, alias Saddam Ali, Abdul Haq, alias Abdul Mia, then we can say, yes, there is a probability of two things, two views. When nothing has been done, even in 330 statement, Lordship, I have flag that in PCR, Lordship, 330 statement, Lordship, he has named his name as Saddam Hussein and father's name Abdul Haq. It is his statement. So when he did not raise question, then he did not stated anything about Abdul Haq, Abdul Mia. Then all at the time after 313 statement, this plea has been taken. And if that plea is been supported by some documents, then we can say. So Honorable Trial Court has rightly passed the order that this person is separate entity. Both these persons are not the same person. So Lordship, this trial will continue. And apart from that, Lordship, on merit, Lordship, and though I have not gone through the entire CD part, and today probably entire TCR has not come, probably. Some part has come, some part has not come. When 313 statement has been over, Lordship, and it is at the stage of argument, so at this stage, Lordship, let that order be passed by the Honorable Trial Court. And there is no any confusion that this person, they themselves has failed that he is somehow related with this person. Only writing that allies will not work. Only writing instead there is nothing similar, there is nothing else in the entire case. Only writing the allies. The allies word, it is going to be connected both the names. Otherwise, nothing is there, Lordship. Lordship, can you see and pass out?
I would just add one thing. Lordship, that his name in the case appears at Saddam Hussein, alias son of Abdul Haq. So some documents have been annexed, document number 1, 2, and 3. One is a certificate issued by the Gau Panchayat. Here his father's name is Abdul Mia. And the election voter I card, here also his father name is Abdul Mia. And this is one birth certificate, which is wherein also his father's name is Abdul Mia. So there are documents where his father name is Abdul Mia, not everywhere his father name is Abdul Haq.
So everything has been newly issued and nothing is there prior to that 2020, prior to the year of 2020.
Which are the annexures?
These are annexure 1,
15, 16,
2,
17.
3. Page 15, page 16, page 17, and 18, one pan card is there of his father.
17 is the birth certificate that has been issued in the on 3/5/2024. Thereafter, Lordship, prior to that, Lordship, Gao Panchayat certificate that has also been issued in the 13/3/24. So all these are prepared, Lordship, nothing else.
Date of occurrence was?
Date of occurrence 23/6/2020.
Yes.
For the respondent number 2, Lordship. Lordship, most of the part has been already touched by learned PP, Lordship. We are affirming with the same, Lordship. But only one thing, Lordship, there is a delay part, Lordship. If something like that was there, Lordship, yes, if Lordship it was there, Lordship, it was well known to their parents, Lord. It was well known to him, Lord. What is his actual name? What must be his signature, Lord? These things are very clear, Lord. If somebody is living from his school with a name, with a certain name, Lord, he will carry that. But he has never carried that, Lord. The original name of that person was Saddam Hussein, as it is, Lord. When he has signature, he has given his name and everything on as Saddam Hussein. It is later on as an afterthought when they thought that there is no other way to get out of this, Lordship. They thought of giving it a chance, giving it a shot, Lordship, that they can prove him as a juvenile, Lord. There's nothing, all the documents that they have annexed, Lordship, if your Lordship kindly see, Lordship, all these documents have been procured in the year 2024, Lordship. Prior to that, there was nothing, Lordship. Although they have a ground, Lordship, this is not maintainable as the documents are very late, as the approach is very late. This is the only part, Lordship, that I will touch, Lordship. Other than that, Lordship, the allegation part is always there, Lord, and it was always there. Nothing has been done in the mid period, Lord. It was only in 2024 when he was arrested again. Then only they have approached.
He was arrested again?
Yes, Lordship. Initially, Lordship, he was granted bail and he was directed to appear, Lordship, but he did not. Later on, Lordship, on NBW was also issued, Lordship. Thereafter, he was arrested again. This is this Lordship. In para 5 of the written case number 6, Lordship, they have stated, Lord.
Yes.
One more thing, one last thing, Lordship. The school living certificate does not contain any picture of the individual, Lord. So it is very difficult for us to identify whether the actual person is the Saddam Ali is the name, Lord, that is given there.
After 7, 7. You are Mr.
Yeah, Ahmed.
A.I.M. or Mr. A.I.M. Or Mr. P.S. So you are Mr. M. Rahman.
W. Rahman.
Oh, sorry, W. Rahman. For responding to an application section 438, 442 of BNSS, praying for setting aside and washing of the order dated 8/11/2024, passed in special box of case number 7 by the Court of Learned Additional Session Just come special just box. It is submitted by Mr. Ahmed, counsel for the petition. Within petition, is not permitted in this box. However, case was registered against the present petitioner wherein he contested the case, and case is presently at the stage of during the trial. They have one petition before learned special judge claiming that at the relevant time of incident, the the accused was a juvenile, and his date of birth as per school certificate is only is 1/3/2003, and hence at the time of occurrence he was only 17 years 3 months 22 days. So taking the ground of they took the ground of juvenility during the trial of the case, and to substantiate the same, and in that regard, the learned special judge also called for the headmaster of 2 schools, and those they adduced their evidence as CW1 and CW2. The the prayer for this need service, both the CW accordingly appeared, and it is the school certificates were produced. Where in both the schools, it is seen that the date of birth is recorded as 1/3/2003. Date of birth is recorded as 1/3/2003, and there is no dispute to that date. The question of genuineness is also raised by the other side, and those documents others. The only ground for rejection of the prayer filed by the petitioner is that in his school certificate, his name has been written as Saddam Ali. Saddam Ali as Saddam Ali, son of one Abdul Mian. In both the documents as well as from in body document is submitted that he is Abdul Saddam Ali, son of Abdul Mia, but he Abdul Mia, but only for the differences in his surname. His name was not considered by the learned trial court. It's submitted that 32 and 33 for examination, non-examination, MOA and IAU, you submitted only in this, and it is in the context of the trial only.
Context of the trial.
If further submitted that there is also no evidence against the present petitioner, as the victim herself did not refuse to go for any medical evidence, and on the basis of which the MO and the I also did not examine at execution during this case. Further submitted in the court record itself is recorded that the you two dates you have submitted. One
Page 27, that is order dated 28/6/2020.
Yes. 27 and
27
and 28.
and 31, page 31.
In the court record also, the name of the present petitioner was recorded as accused Saddam Hussein alias Saddam Ali when the order was passed on 28/6/2020. And in the same time, in another order also, which was this basic 21 is 27 and another one is
29/7/2020. At page number 31.
in another order also, the name of the present accused petitioner was recorded as Saddam Hussein alias Saddam Ali. So further, he submitted that the present accused petitioner is known as Saddam Hussein alias Saddam Ali, and his father is also known as Abdul Mia alias Abdul Haq. So in his school admission register, school records, his name is mentioned as Saddam Ali, son of Abdul Mia. Mr. Ahmed Ekariki submitted that Saddam Hussein and Saddam Ali as well as is the same person in the same time. His father Abdul Haq and Abdul Mia are the same person. So in the school register, only the name of his name is recorded as Saddam Ali, son of Abdul Mia. He further submitted that he also produced the birth certificate. Birth certificate was at page
17.
Page 17, annexure 3.
17. The birth certificate is also produced before the court, wherein also it is stated that he is named as a, what name is there? Saddam?
Here it is named Saddam Ali. Saddam Ali. Left hand side top.
Saddam Ali.
Saddam Ali.
Not Hussein.
Not Hussein here. Yes, Saddam Ali.
Birth certificate also, his name is recorded as Saddam Ali. Son of?
Name of father Abdul Mia.
Without considering the aspects of the case and the not even considering the statement made by the CW1 and CW2, where it is categorically stated that at the time of admission of the present accused petitioner, he was only a petitioner. His and in the school register, his date of birth is placed recorded as 1/3/2003. Accordingly, Mr. Ahmed submitted that without considering all these aspects of the case, the learned special judge had rejected the prayer for the present petitioner and did not consider that the accused petitioner was a juvenile at the relevant time of incident. And hence, on being agreed to the same or present petition has been filed for setting aside an ownership. The order did so and so. Learned special. Next paragraph. Mr. Lockford, the learned petitioner PP, submitted in this that the case is presently at the stage of argument, and till his recording of statement under section 313 CRPC, the accused did not raise the issue of juvenile, nor is disputed his name, and in all along he was recorded as Saddam Hussein and not as a Saddam Ali, and even in the at the time of recording his statement under section 313 CRPC, his name is recorded as Saddam Hussein, son of Abdul. But subsequently, before the argument stage, the issue has been raised, and the petition was accordingly filed, claiming that at the relevant time of incident, he was a juvenile. Further, Mr. Lockford submitted that there is no such supporting document consider that the Saddam Hussein and Saddam Ali is the same person, or this Abdul Mia alias Abdul Haq is also the same person. More so, the birth certificate which has been annexed with the petition was also procured on 3/5/2024, that is, after the incident which had occurred on 23/06/2020. Accordingly, Mr. Kapoor stated that there is no need of any interference in the order passed by the learned special judge, and it has been passed rightly considering all aspects of the case. Next, Mr. Rahman, the learned counsel appearing for the informant, also submitted that there is no irregularity has been committed by the learned special judge while passing the order and rejecting the plea of juvenile. All the documents which were annexed by the petitioner is procured in the year 2024, and though the occurrence took place in the year 2020, and even the birth certificate is also procured in the year 2024, which is much after 2024. Mr. Rahman further submitted that though the two school leaving certificates were produced by the petitioner, but there are no photographs has been affixed in those school leaving certificates for any identification of the person for whom the school leaving certificate was well issued by school. Accordingly, he submitted that he took the plea of juvenility to avoid himself from this case, where allegation of rape of a minor girl is brought against him. Accordingly, he submitted that this is the present criminal petition, criminal petition is dismissed. Oh, আচ্ছা ইয়াতে এটা submission দিব. Mr. Ahmed also relied on a submission or relied on a decision of Honorable Supreme Court reported by 2012 Legal Eagle SC 453 Ashwini Kumar Saxena versus State of Sweden, wherein it has been expressed the view by the Honorable Apex Court that the court should not no, that the hyper technical approach should not be adopted while appreciating evidence adduced by the accused in support of his plea of judgment. Hearing this submission made by Rani proposals. Pass the order is part argument. I have recorded your submission.
Deeply obliged.
Sound. Order. Trial or it will be no, but no, it if order lo আমি রিলিজ সুবের all of parts.
May it please your lordship. Your lordship, in this matter, as per the order dated 9/1/2026, scanned copy of the GR case number so and so arising out of the Paltan Bazar police station case number so and so was called for, your lordship.
CD we have not decided. CD was called for.
It was CD only.
CD and
Scan copy.
scan copy.
The case is already charge sheeted or
Yes, your
charge
lordship.
sheeted case?
Yes, your lordship. As per the last order, as per office, your
Yes,
lordship.
I have seen. What
Yes.
is the office note says?
Yes, your lordship, as per 18/2/2026, scanned copy of the TCR has not yet been received, your lordship, in the Paltan Bazar police station.
Otherwise, it is a case of, I mean, charge sheet has already been filed.
Already filed.
Then we need that scan copy.
Scan.
Yes, your lordship. Kindly a date may be fixed, your lordship.
You are MS. Your good name?
SC Murtaja on behalf of R. Chaudhary.
SC Murtaja, appearing on behalf of MS. R.
Miss R. Chaudhary.
B.S. Crawford, Illinois Division. From the office note dated 18/2/2026, the seen that the scan copy of the TCR is not been received by the concerned section. Issue reminder, the rates you will be in following the scan copy of the TCR in the concerned list. 4, 5. From where it has to come?
Paltan Bazar police station,
Paltan
Kamrup Magistrate.
So, from the court of Chief Judicial Magistrate Kamrup.
Kamrup
Yes,
Magistrate.
come on.
CGM Kamrup.
13/3 will do.
Can it be, your lordship, after 23rd of March?
25th.
Obliged.
Yeah, please, Your Lords. This appeal against judgment and order itself, my lord, convicting the accused person under section 304 part 2 IPC. This is new appeal, my lord.
Admitted.
So
Admission.
May be admitted, my lord.
Bora na iba. The Bora. The learning of the appellant, not should be a it's an appeal in the section 415 to BNSS against the judgment and order dated 11/6/2025 by the sessions in sessions case number 21 SSS 2020 convicting a section 305 is read with section 34 BC and sentenced him to undergo RI for 7 years and to pay fine of 5,000, which deposit appeal is admitted. You made one Biman Chetia as party.
Yes, he's the informant, my lord. Biman Chetia is the informant.
So if you notice that
Yes, my lord.
all for the this year, should to put the to be post and common estimate accordingly 4 weeks as an is your I is for suspension?
Yes, I is for suspension of conviction.
I will
Sentence,
be because probably they cannot submit anything. Do you have any?
After receipt of TCR and in service paper will also be.
Only 7 years, my lord.
No, in that regard, they may not file written
File
objection,
objection, my lord, that's right.
but before him there is nothing.
Yes, yes.
So let the LCR be
My
called
lord,
for.
my lord.
Wait for list immediately on receipt of the LCR. We are listing it immediately in receipt of the LCR.
My lord. Obvious.
Sorry,
Second half also we call you. Yeah, I mean the case was called for.
Malad, I'm sorry.
We are not present.
I was outside, Malad. I'm sorry.
Sir, we don't know whether you are outside or inside.
Like here,
Yes.
Malad, the case is, Malad, a complaint was filed under an act, Malad, against the petitioner by the private respondent, Malad. And the petitioner here challenging the cognizance order passed by the learned trial magistrate, Malad, on the ground that, Malad, the complaint filed by the respondent, Malad, is a premature complaint because at the time of filing of the complaint, no cause of action arose, Malad. Because the cause of
period was not there.
no cause of action. Because, Malad, the cause of action so far, section 138 NI Act, clause 6 says, Malad, that the cause of action will arise after 15 days from the date of receipt of the demand notice. Lordship will find here the demand notice was served, was issued on, Malad, Lordship will find page number 35. It is the demand notice, Malad.
See, all of the size of problem. Demand notice?
Demand notice, Malad.
35.
35 is the demand notice. The demand notice was issued on 4th of November 2019. 4th of November 2019, and it was delivered on the petitioner, my lord. Lordship will find page number 38, my lord. It's a delivery report, my lord. 6th of November 2029, my lord. So for the 15 days time, my lord, that will count from the date of delivery of the report, my lord. Delivery of the notice, my lord. And if it is counted from 6th of November, my lord, the cause of action arise only on 22nd of November. 22nd of November, cause of action will arise. But before cause of action arose, my lord, the complaint was filed on 20th of November, 2 days prior to arising of the cause of action, my lord. That is the case here. In fact, the complainant also, my lord, during her cross examination, she has admitted, Lordship will find page number 43, my lord. The cross examination of the complainant, my lord, that's PW1. Para 16, my lord, page number 43. I issued demand notice dated 4/11/2019 to the accused, and demand notice was delivered to the accused on 6/11/2019. I filed this case on 20/11/2019. On 30th day, on that day, no cause of action arose. So, the learned trial magistrate could not have taken cognizance. So, the cognizance taken by the learned magistrate, it is without jurisdiction, and
stage of the case at present.
Instead, at this instance, the case is fixed for SD, my lord.
Oh, SD. Now we have come.
No, because, my lord, earlier the documents furnished to the petitioner, those documents could not show the date of filing of the complaint, because, my lord, some of the documents were not
No,
furnished.
why you waited for so long?
My lord, only on the date of cross examination, my lord, after going through the original record of the court, my lord, because the documents furnished to the accused at the time of trial, at the initial
Stage of SD, and now we have.
my lord, because only at the time of cross examination, when the original record was seen, my lord, After going through the original record, it was found that the complaint was filed on 20th of November before the cause of action arrest. So anyway, my lord, since the cause of action did not arise and ultimately the cognizance could not have been taken, my lord. So ultimately at this instance, my lord, notice may be issued and the proceeding before the court below may be stayed, my lord. Since it is the prima facie, my lord, cognizance could not have been taken. Cognizance can be taken as per section 142 of the ANI Act only when a cause of action arises, my lord. Section 142 says, my lord.
It's okay.
My lord. It is very clear. Law is very clear. So at the later stage, I have to come before this court only because the documents furnished at the initial stage were not very much clear, and some of the documents were also not furnished to the accused. Still, the proceeding was going on, but only when
No,
at the
they exhibited all those documents.
now the documents are complete because all
No,
this.
no, they exhibited all those documents. So you have you better in front of you while cross-examining, you know all these documents.
Because those documents did not show the date of filing of the complaint. Date of filing of the complaint, it is appearing only.
The record itself, date of filing of the complaint.
Yes,
the record itself, date of filing of the complaint, and other documents are already been exhibited. So you waited till SD. Is it a stage for washing?
No, at any stage. At any stage.
No, whatever. Can it be considered as a stage?
Yes, my lord. Since the cause of action, my lord, ultimately, if an order was passed.
Why you waited so long?
My lord, the documents, those
documents, all the documents were there. They were all exhibited.
No, my lord, only.
Complaint case was filing his notice only there in the case record.
Only at the time of cross examination only it came to the notice of the petitioner accused that the that only after going through the original record of the court, my lord.
So far, Mr. P.S. Crawford PPA bring it's an application PNSS against the order of taking of the learned KMMC 4/3/2022, wherein the cognizance was taken for offense under section 138 NI Act against the present and summonses and summons were issued. It is submitted by Mr. Islam that the cognizance was taken by the learned trial court below at the premature stage and when even the cause of action was not arose. If submitted that the admittedly the demand notice was issued on 4/11/2019 and which was admittedly delivered on 6/11/2019, but without even completion of 15 days, which is required as per law, the complaint was filed on 20/11/2019. Accordingly, he submitted that the cognizance is taken at a very premature stage. Issue notice already. Further considering the submission made by Mr. Islam, further proceeding. Case number state till next. When the next date is your next date is fixed?
Probably on 5th of March. Okay, on 5th.
Okay, stay will be operating after 3 weeks. We are listing. Your stay will be operating.
My lord.
Item number 38.
Highly obliged, my lord.
Yes, what is 38?
My lord, in this case, as per the office note dated 1/12/2025, the service in respect of the sole respondent, my lord, not yet completed. But in fact, in the cause list, I have seen the name of the so many advocates.
Yes, there are so many.
Yes.
Check the names. Yes, obviously.
Names is there. Whether they have filed Okalatnama or not.
এইটো কোনে চাই দিব পাব না 5টা মানৰ নাম আছে 5জন মানৰ নাম আছে নোটটো আকৌ বেলেগ আছে Don't say. Okay, we'll make the direction to the registry for verification.
Yes, yes. It's better, my lord.
Mr. From the office note dated 1/12/2025, it is sent the scanned copy of the DCR as well as the is awaited, a cash copy of the DCR as well as the notice on the sole respondent is awaited. But it is seen that in the cause list there are names of 6 numbers of councils have been reflected in the cause list. Accounts list post. In view of this, the registry is hereby directed to verify as to whether the notice was duly served on the sole respondent and as to whether the councils appeared on behalf of the respondents by filing their bakara. Is the matter accordingly after 2 weeks will do?
After 2 weeks.
Is the matter accordingly after 2 weeks as an agent?
And the my lord, the interim order passed away.
Interim order. Interim order, where from you're saying interim order?
My lord, interim order is there. On 29/8/2025.
Interim we continue to use.
March supply.
Please, Lordship. As per office note dated 4/2/2026, service is not yet complete.
Service is still awaited. The office note. The office note dated
Lordship, there is an interim order.
4/2026, the same that the service is still awaited for the response. Let the service be awaited till the date of listing. Listing matter accordingly after 3 weeks as an edit to fixed registry. Interim be continued till next.
Operation.
Lordship, this I is for section 5 petition, your Lordship, for condonation of delay of 30 days, your Lordship. Notice.
Notice already there? How many? Only state is there or other?
Only state is there, your Lordship.
Only state.
Only state.
Charge is there, Lordship. Done.
Yeah, Lordship.
You are Mr. S.A. Hussain.
Lordship.
You are Mr.
S.A. Hussain, your Lordship.
Pardon, Mr. S.A. Hussain, the learned counsel for the applicant. Applicant. This is an application under Section 5 of the Limitation Act for condonation of delay of 30 days in filing the connected appeal. No, connected appeal or revision?
Revision.
Revision, your Lordship.
Revision against the impugned judgment and order dated 11/9/2025 passed in NDPS case number 379 of 2024 arising out of STF PS case number 06 of 2024 registered under section. I don't know why additional district charges are against it. How is there any other forum? Why revision is there?
Lordship.
You are agree with the order of the additional session judge.
Lordship. Lordship,
Why
against
revision?
Zimma, your Lordship. Zimma of a PAN card and a mobile card, your Lordship.
Oh,
And this is
the
pending.
Jimma only.
Yes, your Lordship.
Oh, achha, okay. Okay, judgment, impugned judgment and order, why? Oh, sorry, impugned order, na?
Order, your Lordship only.
Achha, impugned order was passed by additional district and session judge number 5, Kamrup M, Gauhati, rejecting the prayer of the petitioner in giving to rejecting the prayer of the Jimma petitioner. It is submitted by Mr. Hussain that there is a 30 days delay in preparing the connected revision petition. Why? Where is your explain your delay?
Lordship, it's paragraph number 4, Your Lordship, 4 and 5 years.
Submitted that obtaining the certified copy of the order as well as for preparation of the connected revision petition, it took some time, and hence they could not be filed within the statutory period of limitation, and thus it was filed with a delay of 30 days. Mr. Lockhart, the learned additional PP, there is no objection that considering the submission made by learned counsel of both sides. The grounds mentioned in the petition, which are considered to be genuine, considered to be justified ground. The present interlocutory application is thereby confirming the delay of 30 days in preparing the connected revision petition. Okay, your petition is allowed.
Much obliged.
Five?
He's asking for minimum 540 rupees also.
That was as per the seizure list, actually, Your Lordship.
Yeah,
PAN card along with that.
by not to speak, but I'm saying that
Lordship.
that more than, I don't know, more than double people you have already spent in engaging advocate and all. 540, what to do?
Actually, the PAN card was seized, Your Lordship. That was part of the seizure list, actually. It was dictated, written as per the seizure list, Your Lordship.
Okay.
Much obliged, Your Lordship.
Ask the arrows.
Delays 334.
How many days?
334 days,
Oh,
madam.
there's a big delay.
Yes,
334.
yes.
State is the party, another.
Yes, another
one-
private party is
of
there,
Bonita.
informant. Abonita, yes.
It's an appeal.
Appeal, madam.
Achha.
Against the
What is
conviction
the conviction of under which section?
under section 376,
Oh,
public 511,
achha.
IPC.
Huh? Notice is to go.
No, no.
Party Mr. Sida Silva petition. This is an application under section 5 of the Limitation Act for condoning the delay of 334 days in filing the connected criminal appeal against the judgment and the order dated 18/01/2025 passed by Learned Session Judge Sunit Tejpur in sections case number 119 of issue notice to the respondents through speed post and usual process. No formal notice is required to be served. List the matter to be listed after 3 weeks. We cannot fix a date.
Right.
3 weeks as on a date.